May I please, Lordship, regarding service and records, my case is ready for hearing, my lord.
Lordship, I am appearing for respondent number 8.
Service completed.
Yes, my lord.
Heard Miss L. Sharma, learned counsel for the appellant. Miss Borthakur for respondent number
8, Your Lordship.
8.
Respondent number 8.
Respondent number 8. Ms. Sharma submits that in this matter, service stands completed. LCR receipt,
LCR received, my lord.
LCR receipt, and the matter may be listed for admission hearing. No, for hearing. Accordingly, it is provided that receipt shall list the matter under the column hearing after
Okay.
4 weeks to Purna matter. Sorry.
Usual courts, my lord. No problem. Oh, bless me.
Oh, wait. Inform them. Wait for some time.
Made with option. This is not the delay application.
Delay.
Malad.
How many days?
119 days malad calculated by the office.
Do you have any doubt about this?
My lord,
Have you any doubt about the number calculated by the registry?
yes, my lord.
How?
My lord, the judgment was passed on 8/11/2016, my lord.
Mm.
And thereafter we filed a review which was rejected. And subsequently, my lord, the review was dated 4/8/2022.
Or
I
8/2022.
4/8/2022.
2022.
2022. And this appeal was filed sometime in 23, my lord. December 2023.
December
2023.
23.
22, my lord. December 22. Now, otherwise also, my lord, approaching a wrong forum, my lord, lordship is.
No, that's all right. You were entitled to.
Yes, well. Just, but if this can be not delay may be condoned and appeal can be listed for admission hearing, my lord, if your lordship pleases, and if my learned friend doesn't have any objection to it.
Yes.
My lord, there are two segments. First, my lord, it was dismissed. The judgment was pronounced long back, my lord. After they spent time in the review, my lord, up to 2022, my lord. Afterwards, there is a delay, my lord, 100 something, 19 days. My lordship, the delay can be condoned, but question is that, my lord, lordship can see the last order 4/2022, where there is a clear direction given by the trial court to release the amount within the period of 30 days, my lord. Now, on account of this, my lord, the proceeding, etc., they are not releasing the payment. Therefore, my lord, the party is deprived from getting their legitimate, my lord, entitlement, which is already pronounced by this by the trial court. Lordship, the delay can be condoned, but subject to, my lord, imposing the cost, my lord. That is my prayer.
Imposing cost.
Cost, my lord.
No, you see, we will calculate the
Otherwise, my lord, can you see that
delay from the date of pronouncement of the review judgment.
2,100. It is odd numbers of 2,000 days, my lord.
No. After pronouncement of the decision in review petition.
There is a small delay, my lord. There is no doubt, 100%. Because, my lord, thing is that, my lord, kindly see the time they have spent at their own volition, my lord. It is their persuasion, my lord. Question is that.
No, it is their legal right. They are pursuing
I'm
it.
not saying, my lord. I'm not saying that they cannot, but question is that, my lord, kindly see that it is also lordship also balance the situation. that on last occasion when my lord they are.
No, Mr. Samaria, you say, we are not admitting the appeal. We are only condoning the delay.
My condonation of delay, my lord, delay can be condoned, but lordship, what my prayer is that a cost may be imposed, my lord, because it is there, my lord, part of my lord, action which will create delay, my lord. Why should be the sufferer, my lord? Therefore, my lord, to balance the situation, lordship may impose.
No, you see, if he offered reasonable explanation, and if we accept the same, what is the
Lordship,
question of
my lord,
imposing?
second time submission was enough, my lord, there is no doubt to that effect.
Hmm.
But lordship also kindly see the balance of the situation, my lord.
No, we'll consider at the time of admitting the appeal, not
That
in
is the
this
part,
interlocutory application.
Admission is separate part, my lord. Normally, my lord, suppose it's such an inordinate delay, my lord. Therefore, my lord, our prayer is that.
No, how
our
it
prayer,
is
my lord,
inordinate, you tell me.
Lordship, kindly see, lordship, the thing is that
No, if the judgment is pronounced on 4/8/2022,
in review, my lord,
review, yes.
prior to that, my lord, there is original judgment, my lord. Now it has marched, my lord. with
No,
the
no,
original
no,
judgment.
no, 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 no.
Review is now marched. without-
Article 14,
14.
Limitation Act.
Absolutely, my lord. Wrong forum, it is not a case of wrong forum.
Hmm,
It is a case of entitlement of the right to pursue this matter, my lord. Under order 47, my lord.
hmm.
Wrong forum is that you have chosen certain thing which is otherwise not permissible. Suppose it is not, my lord, provided under law. That is a wrong forum. In any case, the
No,
review-
even then, they have prepared the review petition.
Yes, my lord.
Review petition was rejected,
My-
and we will count it from the date of dismissal of the review petition.
My lord, the review petition can be covered. I'm not opposing that, my lord. My
Hmm.
only humble prayer is that, my lord, entire these circumstances at their own persuasion, my lord. And my lord, the delay which has been caused, my lord, they have to, my lord.
No, we will see at the time of hearing the
My
appeal.
lord, no problem.
We'll see.
That is my prayer only, my lord.
Or Mr. Patra, learned counsel for the appellant, no, applicant, and Mr. Samaria for the respondent. This interlocutory application under section 5 of the Limitation Act is prepared by the applicant for condonation of delay of 119 days. In preferring the connected appeal, challenging the judgment and award passed by the learned member Motor Accident Claim Tribunal Nagaon in MSC case number 443 of 2014. Mr. Batra, learned counsel for the applicant submits that though the learned member Motor Accident Claim Tribunal has pronounced its judgment on which date it was pronounced?
8/11/2016.
8/11/2016. Thereafter, the applicant herein preferred one review petition being review petition number
My lord, it was miss case number 6 of 2019.
review petition upon which miss case number 16 of 2006
6.
of 2019
19.
was registered. And after hearing both the parties, the learned tribunal has dismissed the review petition on 4/8/2022. And therefore, the applicant preferred the appeal, challenging the judgment and award passed by the learned tribunal. Dated, what was the date?
My lord, hopefully it was 23rd of December 2022, my lord. My lord, the exact date is not with me. Filing that's it. 23/12/2022.
23/12/2022.
3/1/2023, my lord.
The process, there was a delay of 119 days in
My lord.
preparing the connected appeal. And the delay has been explained in paragraph number
3 to my lord 8.
paragraph number 3 to 8. What is the ground?
My lord, grounds were, my lord, the files were routed, my lord, from divisional office to the regional office, and thereafter, my lord, the legal opinion was sought, and then the appeal was filed, my lord.
On the ground that after pronouncement of the decision in the review application, the applicant herein had moved the file from Regional office to
Divisional office Tezpur to regional office
divisional
at
office to
Guwahati.
regional office.
At Guwahati.
Regional office at Gauhati, and in the process, some delay occurred. And the same is not intentional, rather it is circumstantial, and under such circumstances, he is contented to condemn the same. Per contra, Mr. Samaria, learned counsel for the opposite party submits that he has no objection in the event of condemnation of the delay. However, he submits that the applicant herein has not been depositing the awarded amount by the tribunal, though there was a clear-cut direction to deposit, or no, to deposit the same within a period of 30 days. And as such, to balance the equity, he has contended to impose some cost. Having heard the submission of learned counsel for both the parties, this court has carefully gone to the application and the documents placed on record, and also perused the paragraph number 3, 4, 5, 6, 7, and 8. And it appears that the delay has sufficiently been explained, and accordingly the same is thence condemned. In view of the order passed in this interlocutory application, now the registry shall proceed to register the appeal and list the matter before the court as soon as practicable.
Obliged, sir.
Item 11.
Okay. Okay. Hello, review.
Item 12.
May I please your lordship? Lordship, in this matter, Mr. D. Mazumdar will appear. Lordship is on his way. Kindly pass over the matter for time, lordship. After
No,
some-
today it is listed under the
It is for hearing on the application for condonation of delay. I filed my objection.
Lordship,
okay. Today delay has to be condemned.
That has to be heard before condoning.
lordship, there are some subsequent developments, lordship, which will be.
Madam?
Lordship, there are some subsequent developments in this matter, lordship.
Okay,
So which will be addressed by my senior.
okay.
After some time.
Obliged.
Item 13.
Only in this way, Elsa is not pent up for last 1 year, in spite of repeated order from her lordship. Last that also explanation was called for, still it was not sent up.
Both the parties are represented by their engaged counsel. Office note dated 5/6/2026 indicates that third reminder was issued to the learned court below for transmitting the TCR, but the same has not yet been received. Registrar shall issue urgent reminder to the learned court below for transmitting the record by special messenger. Registrar shall list the matter on fixed and short date within 1 week. From which court it will come?
From Borpata.
Perfect.
17. 17 June.
17th of June.
17.
17 June. Item 14.
May I please your lordship?
Yes.
Lordship, in the last occasion, the counsel for the respondent was supposed to provide us with the information of regarding the legal heirs of respondent number 1. So that we could take appropriate steps to the substitution of respondent number 1 with his legal heirs. So lordship, in my knowledge, they have not provided us with the information.
Pardon me, sir. Your name, please?
S. Shom.
Learned counsel for the appellant. None appears for the respondent on call. The learned counsel for the appellant submits that the appellant, the respondent hearing is supposed to provide the address of the legal heirs of the respondent number one who suffered demise. When he died, respondent number one. You provide the date to the court master. People who like this. But the same has not been provided, for which the substitution application could not be filed. Accordingly, it is provided that the recusal is the matter. After 2 weeks, in the meantime, the learned counsel for the respondent shall furnish the address, name and address of the legal heirs of respondent number one, list after 2 weeks.
Item 15.
Yes, Lordship, one number 2 and 3 may be allowed for 3 days time I take the step. 2 and 3. Because in the condemnation petition, I took time, step, but in the.
Artesar Arsipal, learned counsel for the appellant, Mr. M. Mondal, learned counsel for the respondent number one. 1.1 and 1.2. Learned counsel for the appellant submits that he may be permitted to take step upon respondent number 2 and 3. Accordingly, it is provided that step be taken upon respondent number 2 and 3 by speed post and also by usual process within a week from today. List after 4 weeks.
Madam.
Item 16.
May I please, Your Worship? As per the order dated 24/2026, we have taken these steps on the sole respondent, Lordship.
Third Miss,
P. Lamu, Lordship.
learned
But-
counsel for the appellant.
Referring to the notes, office note, Lordship, 4/6/2026, there is no response through the sole respondent.
Office note dated 4/6/2026 indicates that no response has been received till date. The office note so put up by the registry appears to be incomplete. Accordingly, it is provided that registry shall issue the registry shall put up one office note indicating whether step was taken upon the respondents by the appellant hearing and whether the same has been received back, received, answered, or any report has been received from the either from the postal department or from the process server. List the matter after 1 week. After 1 week.
Lordship, there is an interim in the IA, Lordship.
Pardon?
There is an interim in IA, Lordship.
Interim order pass earlier shall continue.
TW+.
17.
17 full policy. The affidavit has not yet been received after some time.
Item 18.
Please, your Lordship. Lordship, as per office note dated 5/6/2026, AD card or service report of respondent number 2 is also awaited. And sir, due to some miscommunication on our part, we have not taken step on respondent number 1.
When?
Sir, on last occasion,
Heard Ms. Sharma, learned counsel for the appellant. Office note dated 5/6/2026 indicates that LCR has not yet been received. Accordingly, it is provided that registry shall issue urgent reminder for transmitting the LCR to the learned tribunal for transmitting the LCR. Neither AD card nor answer notice in respect of notice issued to the respondent number 1 is received. Lays the matter after 2 weeks awaiting service report upon respondent number 1.
Item 19.
May I please your lordship. Lordship office note, lordship 4/6/26 indicates lordship respondent number 1 has received a notice.
Mr. Pal for respondent number 1.
Madam, I'm the respondent number 6, Ignatius Research Company.
6.
Correction?
Heard Mr. Kolita, learned counsel for the appellant.
Kindly lordship, item
Mistake, it is a case of.
19.
Mistake.
party number. Item number 9.
Wrong. Just-
Item number 19.
19 lordship, yes. Rubul Ali. National Institute. No, yes. Yeah. So I'm,
You are not here.
he is in other matter lordship. Only 1 has received notice lordship, 2 and 3 lordship, that may be awaited.
I is for condonation.
1
of
is
the-
not there.
Heard Mr. Kolita, learned counsel for the applicant. As per office note dated 4/6/2026, a notice upon respondent number 1 has duly been served. And in respect of respondent number 20, neither AD card nor unserved notice has been received back till date. Lays the matter after 2 weeks,
Yes.
awaiting service report upon respondent number 2 and 3.
Lodge. Obliged.
20.
None appears for the applicant on call, lays the matter after 2 weeks. In the event of subsequent non-representation of the applicant, appropriate order shall follow.
21.
May it please your lordship. Your lordship may peruse office note dated 4/6/2026. Respondent number 3 has filed his wakalatnama. As regards respondent number 2, your lordship service is not completed. It has been returned back as no such addressee in that address. And in respect of respondent number 1, your lordship, as per postal track consignment report, notices were delivered on 8/4/2026. Your lordship.
Heard Ms. P. Borthakur, learned counsel for the applicant. Ms. Bormon for the respondent number 3. Respondent number 3. Office note dated 4/6/2026 indicates that when counsel has entered appearance. No, you have appeared for respondent number 3. Okay. Unserved notice issued to the respondent number 2 received with a postal remark, no such address is found in that address, returned to the sender. Accordingly, it is provided that learned counsel for the applicant shall obtain instruction in respect of the address of the respondent number 2 and take fresh step upon him by speed post and also by usual process within a week from today. Side office note also indicates that neither edit card nor unserved notice issued to the respondent number 1 received till date. However, postal journal indicates that a notice has been delivered to respondent number 1 on 8/4/2026. In that view of the matter, notice deemed to have been served upon the respondent number 1. List the matter after 4 weeks. You obtain instruction and take step in respect of respondent number 2.
Yes.
Item 22.
Here also, your lordship, respondent number 5 has filed his wakalatnama, but in respect of respondent number 4, it has been unserved, your lordship, as no such addressee, and respondent number 1 notices were delivered, your lordship. These are analogous cases, your lordship, arising out of the same accident, your lordship.
Same appeal.
Yes, your lordship. Here also, your lordship, we have to take the instruction, your lordship, as regards the proper address.
Heard Ms. Portakur, learned counsel for the appellant. Mr. Bormon 4, respondent number 5. Respondent number 5. Office note dated 4/6/2026 indicates that unserved notice issued to the respondent number 4 received with a report. No such addressee found in the address. Returned to the sender. Accordingly, it is provided that learned counsel for the applicant shall obtain necessary instruction and take fresh step upon respondent number 4 by speed post and also by usual process within a week from today. Said office note also indicates that notice issued to the respondent number 1. Neither edit card nor unserved notice issued to the respondent number 1 received by the arrestee. However, postal journal indicates that the notice was delivered to the respondent number 1 on 8/4/2026. In view of above, notice deemed to have been served upon the respondent number 1. List the matter after 4 weeks. Everything service report upon it. 4 weeks. You take a step upon respondent number 4.
Lordship.
Item 23.
Here also, your lordship, respondent number 3 has filed their wakalatnama. In respect of respondent number 2, no such addressee, and respondent number 1 notices were delivered, your lordship.
Your আগৰ to say it is the that or আগৰ to একে. Madam, you have for 3. Your আগৰ যে দিলো এটো. Okay.
Obliged.
24.
As per office note dated 3/6/26, steps were taken, but no service report has returned back. But my line of is appearing for
Lordship, we have filed the wakalatnama on 5/6/2026. 2 weeks time will be allowed to.
5 and 6.
Yes, Lordship.
5 and 6.
Yes, Lordship.
Not for other respondent.
For all the respondents only.
All the respondent. Okay. Heard Mr. Soikia, learned counsel for the applicant, and Miss, your name please.
not
Your name.
C. Gogoi.
C. Gogoi, learned counsel for the respondent number 1 to 6. Ms. Gogoi submits that she has the instruction to appear in this matter and will be filing wakalatnama within a period of 2 weeks.
Yes, Lordship.
2 weeks from today. Accordingly, it is provided that recess is the matter after 2 weeks.
obliged, Lord.
Item 25.
I am appealing. I have to file objection.
Okay. You have filed your color number. Heard Mr. R.K. Moore, learned counsel for the applicant. Then also heard Mr. Pukon, learned counsel for all the respondent.
Only one single respondent.
Okay, for the respondent. Mr. Pukon submits that he may be granted some time to file objection. Where allowed, recessal is the matter after 1 week.
Only.
Okay.
On 22nd June, item 26.
May I please, your lordship? Lordship, according to office note dated 3rd June 26, notice to R123 has been taken by speed post and usual process. Unsub notice of R3 has returned. And no ID card of R1 and R2 is received. So postal tracking may
How
be
many respondents are here?
three respondents.
You are appearing for respondent number 1. Heard Mr. Agarwala, learned counsel for the applicant, and also heard Miss S. Bora for the respondent number 1. Office note dated 3/6/2026 indicates that unserved notice issued to the respondent. The notice issued to the respondent number 3 returned with a report. Missent. Accordingly, it is provided that the learned counsel for the applicant shall take fresh step upon respondent number 3. Said office note also indicates that neither ID card nor unserved notice issued to the respondent number 2 has been received till date. Accordingly, it is provided that receipt shall create the consignment and put up an up-to-date office note, list the matter after
Lordship,
4 weeks.
report of usual process may also be placed on without.
Yes, usual process.
Obliged.
27. Twenty-eight.
May I please, your lordship? I for delay of condonation, lordship.
Heard Mr. N. Ahmed, learned counsel for the applicant. This application under section 5 of the limitation act is referred by the applicant for condonation of delay of 267 days in preparing connected MSc appeal against the judgment and award dated 8/5/2025 passed by the learned member Motor Accident Claim Tribunal Borpeta in MSc case number 317 of 2022. Let notice be issued to the respondents returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today, list after 4 weeks.
Item
Diploma.
29.
May it please, your lordship? Let's check for the first time, my lord. Notice may be issued, delay is there. Delay of 51 days.
Heard Mr. Colita, learned counsel for the applicant. This application under section 5 of the limitation act 1963 is prepared by the applicant for relate with section 30 of the Employees Compensation Act 1923 for condonation of delay of 49 days in filing the miscellaneous first appeal against the judgment and order dated 16/12/2025 passed by the learned commissioner. Employees compensation Boyao in EC case number 12 of 2025. Let notice be issued to the respondent opposite parties returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List after 4 weeks.
Highly obliged.
Item 30.
May I please, your lordship? Lordship, there is a delay of 5 days while filing the
Delay of
5 days
5 days.
while filing the connected.
Pardon me, your name, please?
Must be Bola.
Learned counsel for the applicant. This interlocutory application under section 5 of the limitation Act 1963 is prepared by the applicant for condonation of delay of 5 days in preferring connected MSc appeal against the judgment and award dated 28/12/2025, passed by the learned member Motor Accident Claim Tribunal Dhemaji in MSc case number 16 of 2023. Let notice be issued to the respondent returnable in 4 weeks. Step be taken by speed post and also by usual process within a week from today. List of reports.
Item 21.
Lordship, this is a delay condonation petition of delay of 4 days, Lordship.
4 days.
Yes.
Okay, let notice go. 4 weeks.
32.
Please, your lordship, I ask for delay for donation.
How many days?
70 days.
70 days. Okay. After 4 weeks.
33.
Obliging.
Item 33.
Non-request for the applicant can call list the matter after 1 week. In the event of subsequent non-representation of the applicant, the appropriate orders will follow.
Pending items. Item number 9.
For the last meeting, the matter was now placed before the higher authority for approval.
For
For approval.
approval. No, the file was transmitted on 7/5/2026.
Yes, sir.
Today we are in June.
Meeting was held in the month of April, my lord,
Mm.
with the finance department. Then
Mm.
finance department request to take the concurrence of the higher authority. My lord.
Mm.
Now, my lord, 5 was placed before the higher authority. My lord. So, my lord, kindly, there was at least 2 weeks time, my lord, so that approval can be obtained and the further process can be.
Part Mr. Islam learned counsel
May I
for the-
submit, my lord? My lord, direction was given to comply the order within the 3 months. My lord, 3 years has gone, my lord. They are raising one after another new issue, my lord. Similar situated, my teacher has received the salary, my lord, and they are delaying, my lord. It is, my lord. Lordship, kindly see the grievance of the petitioner, my lord.
No, Mr. Attorney,
Yes, sir.
the file was endorsed to the higher authority on 5/7/2026.
7/5.
7/5.
Yes, sir.
So since then, 1 month elapsed. What is the outcome?
That is, my lord, because this letter is of 6/6, my lord.
Hmm.
File has also returned till date, my lord. That is, my lord.
No, I have submitted by him 3 years elapsed.
Then I understand, because this is regarding creation of post, because the additional given to consider his case for consideration, and finally it was found that he is eligible. So now it is a creation of post, madam. That is why it was placed before the higher authority. Madam.
When he was found to be eligible,
It is in the last meeting, my lord, that was finally
last
decided.
meeting was held in which year?
This year, but 24/4/2026.
26.
In fact, in the last order, it has been reflected, madam. On that day, meeting was held, my lord, with the finance department.
So when we can expect the compliance of the order?
Yes,
Well, at least it will be 2 weeks time, my lord, so that once approval, we can obtain the approval, then we can proceed, my lord. So my lord, we give me this 2 weeks time. So that latest status I can obtain, thereafter, I can give a definite timeline, my lord. By what time?
Heard Mr. Islam, learned counsel for the applicant, for the petitioner. And also heard Mr. Khatonia for the contemptors. Mr. Khatonia has produced one letter dated 6/6/2026. Issued by the Deputy Secretary to the Gauhati of Assam Department of School Education, addressing the Senior Standing Council, Guwahati High Court. And on the basis of the said letter, Mr. Khatonia submits that the file was endorsed to the higher authority by e-file number 295395 on 7/5/2026. And he submits that he may be granted 2 weeks' time to apprise this court about the up-to-date status of the said file. We are allowed to list the matter on after vacation.
Yes, my lord. Immediately after application, my lord.
Immediately on 13th of July.
Let,
The letter produced before the court today shall be marked as Annexure X. No, not X, A, and we take to the record.
keep it part up, it is already released
Let's
from
shall
part.
keep the matter as part of.
Offense.
Nice.
Pending item 12.
I'm sorry, man, I was late in coming today. Hello, this is a regular first appeal against a money decree. There is a money decree against me of about 86 lakhs. In fact, there was an agreement to sell and an advance payment was made. Subsequently, the sale did not take place. So the purchaser filed a money suit for recovery and decree has been passed. My lord, this basic ground on which there is a delay of 240 days, 44 days, my lord. The
44 or 46 days?
244. Yes, 246. What has happened basically, my lord, the appellant fell sick and initially he was in touch with the lawyer. Subsequently, he lost all connection with the lawyer, although the lawyer was suggested that as and when there is a requirement of presence, etc., he would inform. But he also fell ill with my lord kidney, then heart. He was bedridden for some time, so he couldn't contact with the lawyer. Lawyer also did not inform him. And evidence was also not adduced on behalf of the defendant, my lord, and suit was declared. Only after execution case was filed and notice was received of the execution case, they discovered that there is a judgment and decree in the money suit against them. That is why there is a delay. My
No,
lord.
no,
I explained
application was filed for
execution, my lord.
execution.
My lord, only my lord, lordship may kindly see page 7, my lord, paragraph 7. I have explained, my lord, all the earlier developments, how he lost contact with the lawyer because of his ailment. I have annexed all the documents also. He had a 70% blockage of heart, then kidney problem. He was shuttling from Silchar to Gauhati for treatment in various hospitals, my lord. Page 7 and paragraph 7, my lord. Lordship, kindly see. If your lordship has got, my lord, may I read it? The applicant states that he, in fact, came to know about the judgment and decree dated 19/12/2023 when the plaintiff filed money execution case number so-and-so in the money suit number so-and-so as on so-and-so 31/8/2024 in the Court of Civil Justice Division number 1, Kachar Silchar, and he received notice of the same. Before that, my lord, they specifically stated that the lawyer did not inform me. Even evidence was not adduced, my lord. So practically, the plaintiff has got a walkover. Suit was decreed. Now, my lord, here my learned friend possibly informed that there are some developments. What has happened, my lord? They have filed the execution case there, and we have filed the appeal here with some delay, and there is an application for condonation of delay. They have entered appearance, but somehow they didn't file their objection. Only the other day they have filed. And my lord, I actually have the intention of satisfying the decree. I mean to pay the amount. The only difficulty is, my lord, they are not allowing me to sell the house. If I contact a person, I arrange a seller, he will go and say that, no, please don't buy, there are some litigations. Because if the house and the land is sold in execution, auction, my lord, naturally he will manage and show a lesser price. And we have given specifically, there is one person who is behind the whole, my lord, story. He is not allowing us to sell the land and pay the, we are practical, man, we have filed an additional affidavit saying that we are actually praying before this court, although we have filed the first appeal, we are praying for a direction that kindly allow me to pay the amount in installment. I want to pay and satisfy the decree. I am not going to challenge even. Specifically, my lord, we have filed an affidavit. This is the position, my lord. Now what has happened? Well, this is pending here. On the last occasion, my lord, we have filed, my learned friend was here. We have filed an application saying that, see, we want to sell it and he is preventing us. This was informed to my learned counsel here, my lord. The very next day, they have filed an application there for attachment, stating that I am clandestinely I am going to sell the property, and for execution, for attachment and auction sale, he has filed the application saying this. This is absolutely not correct, my lord. On the previous day, in the presence of my learned friend, we informed this court and filed an application saying that we want to sell the property. We are trying to sell, you are preventing us. There is no question of hiding anything. And the next day they filed an application, attachment order was passed initially, and subsequently the steps are being taken for auction sale, my lord, hurriedly. And we are filing a revision petition. We have just received the certified copies of the orders. Najir has been informed to report. So they are proceeding very fast.
No, Mr. Majumdar, you say
My lord.
this is an application for condonation of delay.
True, my lord. I've just given the background, my lord. I am praying for condonation of delay. I have specifically stated in various paragraphs that I was unwell. I have annexed all the medical documents. I was unwell. Lawyer did not inform me. And only when the appellant, petitioner before your lordship, received the notice of the execution case, he came to know about the case. Thereafter, immediately he took steps and filed the appeal. In the meantime, a delay of 244 days has occurred, my lord.
Yes, Mr. Chakraborty.
My lord, there are judgments, my lord. Possibly I need not cite those judgments about sufficient cause and.
Let us hear
My
from him
lord.
first.
So,
What is your objection?
payment objection. To start off with, my lord, my senior colleague has cited the reason of illness, that is medical ground. Now, the documents which have been annexed in their delay condonation petition, those pertain to a period between 1/5/2022 and 4/5/2022.
I'm just sorry to interrupt, my lord. I am not on illness, my lord. I said because of my illness, I lost contact with the lawyer, and lawyer did not inform me about the judgment. And let us be very clear. I am not saying that because of my illness, there was a delay. Delay was because the lawyer did not inform me. And I came to know about the judgment and decree only after I received the notice of the execution case.
Then I don't need to argue on the point of illness. Now the question is, the blame has been put upon the lawyer. And my lord, the excuse that for fault of the lawyer, the party should not be made to suffer is perhaps what is being sought to be projected. But my only contention here is, this was a contested case. It was not that it was an ex parte proceeding. It was a contested case where at certain point of time, after a certain point of time during the suit proceedings, the appellant failed to adduce evidence. Eventually, the decree was passed. My prayer in the plaint was for attachment of the property so as to satisfy the decree, and the suit was decreed entirely. So eventually we filed our execution petition in money execution 14 of 2024. Now, after all this, all throughout they were contesting the case. At the stage of evidence, they did not find the evidence. Then the judgment and decree was passed. And now the contention that has been taken up here is that a decree of 19/12/2023 came to their knowledge on 31/8/2024, almost after a year, after the filing of the execution case. My lord, this excuse could have held good at certain point of time earlier, but today, in the present days, where there is this CIS facility for lawyers as well as litigants, Now, nowhere in the delay condemnation has it been stated by that the appellant is illiterate or uneducated so as not to accede to the court information system to know about the status of his case. He was all along aware of the developments which were taking place. Even in money execution case, when he received notice, he came before the executing court and he filed petitions after petitions with only one prayer that the money execution may be kept in abeyance because he is about to file appeal. And eventually, the appeal has been filed on 21/11/2024 against a judgment and decree of 19/11/2023. Now, my contention here, my lord, is that so far as explanation of the delay is concerned, it miserably fails because though my senior colleague is saying that illness is not taken as a ground for justifying delay, but illness has been cited. Here, the medical documents have been annexed, but my submission here would have been that these medical documents pertain to a period from 1/5/2024 to 1/5/2022 to 4/5/2022. For a period of 4 days, he was admitted. There was an angiography conducted. Eventually, there was an outdoor consultation on 16/12/2022, where there is no such indication regarding the seriousness of the illness. But this medical documents been annexed. But my point is the judgment and decree is of 19/12/2023. These are medical incidences 1 year prior to the passing of the judgment and decree even. And after the judgment and decree, they have come after 1 year before this honorable court in appeal after the filing of the money case. And most importantly, my lord, one thing that I have taken as one of my stand in my objection is that what survives in this RFA, because it has already been considered by the appellant that they are going to pay the money to satisfy the decree. This has been done by way of an additional affidavit that is on record. Your lordship has perhaps gone through
No,
it.
that's all right, but if you were not allowing to sell him the property, then
And allegations are very specific, naming the person who is doing all the mischief. We have named that person.
Look, my lord, here my counter to this stand would be, who am I to or not to allow him to sell the property? This is the property under attachment. This is
no,
the
the
property.
attachment was made
my
on the
lord,
basis
this
of
is-
the
that is
application
incorrect.
filed
Now-
by you.
Well, that is at our instance. We have made a prayer in our suit.
Yes.
Your lordship will kindly see my play. In the play, my specific prayer is for attachment of the property for satisfaction.
No,
of the
that's all
decree.
right, but unless he sell the property, how can he will make payment
No,
of the amount?
Your lordship kindly sees, he has failed to pay the decretal amount within the stipulated time as stipulated by the learned trial court. It was directed that the amount be paid within 6 months, failing which there would be interest. Now, since there was no payment after passing of the decree for 2 years, in the year 2023, the decree was passed, not a single penny has been paid till date. So we were bound to approach the learned executing court in the execution case. During the execution proceeding, the property has been attached. Now, so far selling of the property and recovering the decretal amount, this now is the prerogative of the learned executing court. Who am I to or not to allow him to sell the property? It has already been attached.
No, it was at your instance.
At my
Yes,
instance.
and after the judgment. Attachment before judgment is one thing, my lord. He filed an application for attachment before judgment, it was not passed, no order was passed.
That is it.
So attachment after the judgment, my lord, is different. You are not allowing me to sell on the one hand and you want that it should be sold in auction.
Be that,
My lord, we have named the person, it is PW2 who is doing all the mischief.
be that as it may, my lord. Now, my contention here is, even I am also not, my lord, interested in prolonging the litigation only for the sake of prolonging. My contention is that they have filed an additional affidavit where they're saying that if they're allowed to sell the property, it will fetch them a higher market value and the decretal amount would be satisfied and they will also be benefited in a way. Very good. Let them go to the executing court and file an application. The executing court will take care of that. This honorable court sitting in first appeal perhaps may not venture into all these things because this is by way of an affidavit. This is not even by way of an IA. What they are saying is that if they are allowed to sell the property, they will satisfy the decretal amount. In a way, they have conceded to the decree. The RFA is in front. The RFA on merit is literally infructuous in view of this affidavit because they are saying that they will sell the property and satisfy.
My lordship may have a look at these two orders, my lord. Hurriedly, two orders were passed so that it is sold in auction. We are unable to prevent the auction sale, my lord. My lord, the plaintiff should be interested in getting the decretal amount and not in selling the property in auction. When we are saying that we are ready to pay you,
Well, they have said this before this honorable court.
Yes,
They have not
now-
said it before the learned executive.
at least we have said now.
Let them say that before the executing court where it will be an appropriate forum for them to say. And these, my lord, whether there is any judicial impediment, there is any legal impediment in passing of this order, there is no stay.
So Mazumdar, let both the party go and file an application before the.
We'll file. In fact, my lord, we are challenging this order. Today, we are filing a revision application challenging this order. Because, Marlo, when we say that we are ready to pay you the decretal amount, why are you coming in the way? And there's one gentleman, his name is Asim Das, he is PW2. And my lord, we have taken a specific plea in the additional affidavit that he is preventing and he is intimidating. We have mentioned here, my lord, the respondent particularly said Asim Das, PW2, has intervened and intimidated the prospective buyers. They are not allowing me to sell them a land, my lord. Why? Are you interested in the decretal amount or interested in making a, my lord, through illegal means some extra money, generating some extra money? Because your lordship knows, my lord, in the auction sale, anything can happen. And a property worth rupees crore will be shown to have been sold by for an amount of rupees 10 lakhs. This is what we are apprehending. And his conduct we have already shown. A person who intervenes and intimidates the prospective buyer, what else can be alleged against him? My lord, my submission, lordship will kindly condone the delay, admit the appeal, and thereafter we are file revision. We are filing today itself against this order, and we are repeatedly saying one thing that, unlike other cases, here the man wants to pay the money. Only thing is he wants to sell. He arranges a buyer. He intimidates, and a sale cannot take place. This is what is happening in this case.
Well,
Intentions are very clear. He wants to pay the decretal amount. He wants to satisfy the award decree.
But my proposition would be, my senior friend is saying that let this delay be condoned, let the appeal be admitted. So in a way, he is also, my lord, insisting on the judgment and decree that has been assailed to be interfered with, at least by admitting the appeal. But at the same time,
No, if you are not allowing him to sell the property and to satisfy the decree, what way is available to him?
categorically denied such allegations. In our objection, we have categorically, these are fact findings, my lord. These are something that they have said.
Mr. Sokorute, you say, Mr. Mazumdar is a senior advocate.
Well,
He had made a submission before this court. So
Well,
do we ignore it?
no, that is, well, it's something that I'm not.
Then-
In fact,
that-
I am.
Your lordship will kindly.
My learned friend has specifically informed him that, see, you did not adduce any evidence, you will have to satisfy the decree. And thereafter, pursuant to his advice, my lord, he has agreed it is, we want to pay, but I am unable to sell the property. This is the only problem in the whole matter now.
So, my lord, may I concede to one thing, my lord? Let this matter be relegated back to the executing court where this matter is now under adjudication. Let them make an application before the executing court that they want to sell the property and satisfy the decree. The executing court will obviously pass an order to the extent that they want, because here, my lord, my only thing is, if this would have been an IA before the honorable court, your lordship would have passed an order. This is by way of an affidavit that they are only stating on oath that this is what they are intending to. This is not by way of something. Even, my lord, if your lordship passes an order on the taking into consideration this affidavit and relegates it to the executing court, I have no problem at all, my lord. I am only interested in the decretal.
No, let us do one thing.
My lord.
we keep this matter pending. We will not pass any order now. Mr. Mazumdar, go and file one application.
But
there.
we'll file, but then in order to enable this honorable court to pass an order, my learned friend is suggesting the delay has to be condoned, appeal has to be taken up for passing some order. Unless the appeal is admitted, your lordship will not be able to pass any order in it. In what case your lordship will pass an order?
This order can be passed, my lord.
No.
My lord, in this
Your lordship will derive jurisdiction to pass an order in this appeal only when the delay is condoned, appeal
No,
is admitted.
that is all right. Let us keep this IA pending.
My lord.
You file an application there, and thereafter we will take a call upon this.
My lord, there is no difficulty, but otherwise, my lord, for the purpose of resisting my prayer for delay condonation, this cannot be a ground, my lord, that let them file an application. Lordship, what I'm saying is, my lord, I'm assuring our client will file an application before the lordship may kindly condone the delay, admit the appeal, let it be listed for admission on the next day. In the meantime, we are filing a revision against that those two orders, my lord. And we'll file appropriate application.
Since you are going to file an application before the executing court,
My lord.
you no need to hesitate against these two orders also.
We
You,
need not file any.
Yes, not necessary.
My lord. That can be
If,
done.
Mr. Chakraborty, advise your client.
Absolutely, my lord. I can undertake, my lord.
Otherwise, we will admit we will condone the delay and we will admit the appeal.
My undertaking may be recorded, my lord. I'm giving an undertaking.
No, today I will not record any undertaking. Both the party approach the trial
difficulty is
court.
unless your lordship passes some order, the executing court is proceeding. Executing court has directed the Nazir to submit a report, and there is an order. Second order, lordship has seen, prohibitory order by which I cannot take any step to sell the property. If that order remains, executing court cannot pass an order against its earlier order. These are the technical difficulties, my lord. There is already an order, first order of attachment and second order of prohibitory nature, directing the Nazir not to allow them to sell the property or anything like that.
My lord may make some observation in view of the additional affidavit that has been filed by the appellants. Because that has been filed in the delay condonation petition of its submission. The additional affidavit that they have filed. Your lordship can very well take judicial.
In fact, my lord, my suggestion will be like this, my lord. I have already expressed the intention of my client. Lordship may condone the delay, admit the appeal because only admission will take place on the next day. In the meantime, we are filing the revision, my lord. In the revision, lordship can pass an order like that will approach the court below because we'll be filing the revision against those orders passed by the executive court. In that revision, lordship may pass an order that we should approach the executive court with appropriate application. There, lordship can pass an order.
I still stand to oppose regarding the condonation of delay. I don't see any difficulty, my lord, why my senior colleague is insisting on an order to be passed only in the appeal. It can be passed because they have filed this additional affidavit in this delay condonation petition. In the IA, they have filed this.
Without admitting the appeal, where your lordship pass an order? In which case?
My lord, your lordship kindly, well, just for a moment, my lord. Your lordship will take note of the statement that they have made on oath in this delay condonation petition. Your lordship keeps this IA pending. Your lordship, my lord, makes an observation that they can very well produce before.
That's all right, but Mr. Chakraborty, you see. This application is only for condonation of delay. So would it be proper to pass or issue such kind of direction in this IA?
Not a direction. I'm only saying your lordship, my lord, makes an observation, taking note of their additional affidavit, the stand that they have taken on oath. If that observation is made in today's order.
No. Is it necessary? You see, they have filed an additional affidavit. It is part of the record now.
I understand.
So
that is why, my lord, if this is taken note of as an observation in today's order, keeping the delay condonation pending and enabling them to file an application, making the prayer before the learned executing court to allow them to sell. In view of what they have stated in this additional affidavit, I don't think there will be any difficulty, my lord.
This is not the procedure. My only submission is this is not the way an order is passed. Unless your lordship admits the appeal, lordship cannot pass any order. In the additional affidavit, I have brought to the notice of the court certain developments, but there is no prayer that your lordship will pass an order. This order my learned friend is suggesting can be passed in the revision if I file a revision against those two orders. Not here. This is only for the purpose of informing this honorable court that how they are delaying this. They got the notice in the month of January. They have filed the objection to my application for condonation of delay only the last day, my lord. That itself is a ground to condone the delay, my lord.
My lord, I leave it up to the, my lord, judicial discretion of this honorable court. Only thing is my senior friend is insisting on admission of the appeal. If there is to be admission of the appeal, then I'll have to insist for payment of 50% of the decretal amount, because otherwise the money decree cannot be, my lord, admitted and.
No,
My
no,
lord,
today,
procedures can be
no, no,
amended.
Mr. Security, you see, today we only condone the delay.
Yes.
Only thereafter they will register the appeal and list the same before the court.
Then when I pray for stay of the execution of the decree, then their question will come, I have to pay deposit 50% or not.
Okay, let us condone the delay.
My lord, I leave it up to your lordship, my lord.
And let him file a revision against this orders
Yes,
also.
that against that I'll file one. Let the if it delays condone, my lord, let the appeal be listed for admission on in the next week.
Okay, we'll condone the delay.
My lord.
We'll pass the order.
Lordship will direct, my lord, for registration of the.
Yes,
My lord.
only direction will be to register the appeal.
My lord. Certified copy to oblige, lord.
How many item? 70?
Lordship, they had filed an affidavit in opposition on Friday. I may be granted some time to file a reply, Lordship, if required.
Is there any provision in filing
Lordship,
affidavit
there is
and reply?
provision in filing an opposition also,
Huh?
but then we may be allowed to go through it once and then maybe fixed after the vacation.
Where is the provision for filing affidavit in RFA?
My lords, the law is set and as per the judgment of the Honorable High Court of Delhi, Calcutta and Madras.
Law is settled in
that
respect of?
in respect of that, if it's a company petition, there has to be an authorization by the board of directors authorizing a particular person to institute or file a case. I've annexed the judgment of the Honorable High Court of Delhi, Calcutta and Madras in my affidavit in opposition.
Maybe those judgments have a persuasive value upon this court. We may not follow it.
But my lords, if we are not.
No, my
at
question
least
is,
on
my
behalf-
my question is there any provision for filing additional affidavit or reply affidavit in RFA?
At least my lords, a board resolution on an authorization letter should be there.
No. Is there any provision in the CPC for filing such an affidavit and reply?
My lords, I have to check, but my lords, the judgment here, it's clarifies.
No, I am asking you about CPC,
But
not the
I'll
judgment.
Check and come back, my lords.
Heard Miss
K. Bhattacharya.
Learned Counsel for the appellant
Yes, Your Lordship.
and Mr.
Shomuchina.
Learned Counsel for the respondent. Ms. Bhattacharya submits that the respondent herein have filed an additional affidavit and she may be granted some time to go through the same. Fair allowed, list the matter. After a week?
After vacation, Lord. After vacation.
No, after a week.
After a week.
After a week,
Lordship.
Just carry please after 20 years.
28,
20.
20, correct.
Right after the court opens after vacation, Lordship, on 14th, Lordship,
No.
22nd June.
26th. Lordship.
How many item? 11.
Again. Against the my saying Okay, আৰু মাতি থাকিব নালাগে এবাৰ ইনফৰমেশ্যন দিছে তো অলপ দেৰি ৱেইট কৰক নাহিলে অলপ দেৰি ৱেইট ফৰ সাম টাইম
Yes, my lord.
Uh,
Family item 27.
Worship, we made an application before the Guwahati Circle asking for giving the status of that Masjid Goli Road. And we received a reply from the circle officer. It has been stated that Masjid Goli Bhangagar does not fall under the jurisdiction of the Guwahati Revenue Circle. Therefore, my learned friend is claiming that DAG number 1654. It belongs that Masjid Goli also falls into that DAG number is not correct. This is an independent road, it is a public road. And my learned friend is trying to claim that property to be his own and trying to persuade the vendors to enter into agreement with that person, Lordship. Therefore, that impugn order is not correct, Lordship.
I will submit, Lordship.
This is the copy, my application and the order reply from the circle office.
Obviously.
It may be in different revenue circle then.
Yes, Lordship. It falls under number 2 Zaporigo village under dispute circle.
Under dispute
Dispute
circle.
That
You
report of
obtain
the,
information from that circle officer then.
this is report of the Latmondal. He had given that information in his report.
You obtain the required information from that circle office.
From Guwahati.
Dispute.
No, we obtained information from Guwahati Circle because that property, which is claiming to be 1654, that number that falls under Guwahati Circle, as claimed by my learned friend. And this Masjid Goli does not fall under that Guwahati Circle.
If I may only submit, Lordship. Lordship, the instruction that they were asked to produce, Lordship, is whether Masjid Goli that runs through my plot of land is a public road or not. That was their board of potential, Lordship. So now.
Mr. Ali, that's all right.
That's Lordship.
But if it does not fall under the jurisdiction of circle office, it's,
But because my GMC order that has been given to me, Your Lordship.
Guwahati Revenue Circle, then how can they furnish the requisite information?
Lordship, my submission is, Lordship, the GMC order that has been granted to me, that was with respect to specific DAG, Lordship. I have never said that I will apply by running a market beyond the DAG, Lordship. The thing is that I am saying that this is the DAG, and with respect to this, there is one road over which I am running the all the market road. Now they are claiming that this is the road which they claim is in a separate Lordship, circle revenue circle, Lordship. So as regards that, if that is true, then they will have to produce a test map showing that this is the road and this comes to a different different DAG, Lordship. So as regards whether this Masjid Gully, what they are saying, because my road, I have already pointed out before the Honorable Court that this passes through particular DAG, Lordship. Now in Binang Zaporigo, what is there? Until a test map is produced before the Honorable Court with all the records, whether this is the road or some other road they are speaking, I cannot compare, Lordship. But the thing is, I am literally saying that I have been allotted the market with respect to particular DAG, Lordship. 165. I am not going to run market beyond that DAG, Lordship. If they can, that's why on the earlier occasion, the Honorable Court has directed them to you produce any document that shows that this is a public road. Whatever the road name is, Lordship. But if it is a public road, I don't have a right. And if it is a public road, because GMC or any other authority is not asking me to restrain from running the market. Now, when I am being ordered by the GMC to run a market, And they have, without any objection, Lordship. That is also, they have also shown that the GMC is restraining this. Because it's the GMC market that I'm running, Lordship. And as is fact, I am saying that there is government which says that 1654 comes within me, and I am only allowed to allowed to run market within the area that falls under that. And I am saying that within that road is going, over that there are certain vendors, they will have to extend this is an order until this order limitation was 12 months. Within 12 months, if they want to wish to run any market, they have to enter into an agreement with me and pay the fees. Now, if they can produce any document from the either from the GMC, either from the Zaporico Revenue Circle, showing that this is the dark, this dark number is within so and so within Zaporico, dark number is Masjid Gully, Lordship, or is public road. My case is that is a simple thing that this court will ask to Lord. But they are saying one Masjid Gully that doesn't fall under Ulubari Circle. But they have not shown that at Masjid Gully they are saying they don't want me to continue the market is a public road or it doesn't fall to my time. That can only be done between the trial.
Mr. Sharma,
Yes, sir.
you obtain information from the dispute revenue
The
circle.
Lordship, that can be done, but what I am placing before your Lordship is, Lordship, may kindly see page number 28, from where they are deriving their rights. Page 28, this is a Zomamundi issued in their favor for Doug number, Patta number 585, Doug number, as they claim, 1654. Now, this Gauhati Circle is stating that this Masjid Gully does not fall under Gauhati Circle. The Mondal verified the place. The circle officer has given his report. The original has been placed before your Lordship. So what they have stated that this Masjid Gully does not fall under Gauhati Circle. Therefore, we cannot give any information. But the thing is that this 1654 Doug number never falls under dispute circle. This Doug is of Gauhati Circle only. And if it is this Doug is of Gauhati Circle only, then their property, their land falls in that 1654 and that does not fall under in the Masjid Gully road. Masjid Gully falls in different revenue circle. Therefore, this Masjid Gully, no part of Masjid Gully falls in Doug number 1654. And they have the claim only over Doug number 1654. The order of the GMC also, your Lordship may see at page 31. They have given the right to run market in Doug number 1654, but number 585. And if these persons, petitioners, if they are running their business in the Masjid Gully, opposite to their plot, opposite to their building, how this person fall under that his property under Doug number 1654? And if they do not fall, please, that's one minute. If they do not fall in Doug number 1654, where is the appellant's right, plaintiff's right to pray for an injunction to enforce us to enter into an agreement? Because this is not his property.
Mr. Sharma, you say that will be considered at the time of hearing of the first appeal.
Yes.
This is we are now in the IA.
Yes.
IA for staying the impugned judgment in order. The question is if the said plot of land falls under the jurisdiction of circle office dispute.
Yes.
You obtain a report there.
I can
Will
obtain,
grant
Lordship.
you.
Yes.
Till then you don't.
That is what I'm saying, Lordship. And if they can obtain that report, then the first date of filing objection has gone. Let them appear.
No, till then you don't evict them. Though we are not going to pass any order. You produce it on Friday.
Lordship, next week, Lordship.
Next week.
Because I cannot say.
Heard Mr. Sharma, learned counsel for the appellant, applicant, Mr. Ali for the opposite party. During the course of hearing, Mr. Sharma has produced one report of the circle officer dated 6/6/2026, and as per said report of the circle officer, Gauhati Revenue Circle, the road of Gauhati Bhangagar Masjid Gully falls under the jurisdiction of Dispur Revenue Circle. Revenue Circle. And in that view of the matter, Mr. Sharma is directed to obtain the report from the circle officer, Dispur. Rest is unless the matter on Next, Wednesday, Tuesday,
Wednesday,
Wednesday. Okay.
During this development in second place, Lordship, few of the petitioners in this petition, the opposite party, they have already entered an agreement with us. Almost 12 to, I heard 12 to 49, don't know the exact number, Lordship, but they have entered agreement with us. So I think, and we will be striking out their name in the plaintiff, in the suit. So my humble friend, he can also learn whether they want to
let
proceed or
them,
not.
let them give us some letters.
I have the agreement copy. They have entered into agreement.
Because there is no instruction
That's what
in this matter,
I
Lordship.
obtained the instruction letter that I
So-
just submitted the court, Lordship.
Okay, on next day you obtain instructions.
Lordship, I have.
Both of you. And appraise this code and produce the agreement.
Yes, I'll provide the agreement, because
Lordship, can it be on 18th, Lordship? 18th. Interim order is continuing, Lordship.
Interim order passed earlier shall continue.
Obliged.
No, whether we have any, we have passed any interim order here.
Not insisting him not to take any steps.
not
Lordship.
taken court, sir, not.
Okay, okay.
That's clear. So they are already given.
And Lordship, can we take back that original copy?
Yes, you
by
can.
Producing.
Xerox copy.
Letters for admission.
Lordship, I'm just recapitulating the facts, Lordship. Here in the petition, I applied for the post of principal of National HS School, Lordship, in Lamding. The advertisement was of 21/6/2016. Subsequently, interview was
Okay,
held.
Mr. Sharma, the standing council of the secondary education.
Lordship, he was here a few minutes back. Lordship, the interview was held on 14/12/2016. But subsequently, one Ratnadatta approached this honorable court with a plea that the constitution of the school selection committee was not in accordance with the provisions of the 2003 Act. And this honorable, after consideration of that fact, Lordship, said that since the matter was still pending before the state selection board and it has not been finalized, so there was a direction given to the state selection board as well as to the government to finalize the selection process. Now, after that, Lordship, the school selection committee, the panel was prepared, Lordship, and basing upon that panel, Lordship, my name was at serial number 1. Basing upon that panel, the state selection board subsequently recommended my name before the government, Lordship. The government, what they did, Lordship, they said that since there was a flaw in the selection process by the school selection committee, Lordship, amongst those candidates who applied for the post, the selection is to be done afresh, Lordship. Now, the selection was done afresh in terms of that order. And in the meantime, I approached this honorable court by filing this petition, Lordship, and this court protected me by saying that, Lordship, the interview may be held amongst the candidates who had appeared earlier, Lordship, and in the meantime, the results may not be published, Lordship. And subsequently, Lordship, at page 55, the panel that was prepared by the school selection committee was forwarded to the inspector, and that was Lordship disclosed, Lordship, before this honorable court from the seal cover, Lordship. Now, in terms of this, it's at page 55, Lordship. In terms of this, I am in the panel, Lordship. A panel of 3 is to be prepared, and I am the third one, Lordship. And
So, Mr. Sharma,
Lordship,
now you are not going to pursue this
No, Lordship. I want that the process may be finalized, Lordship. Because I'll retire in November, Lordship, this year.
No. The challenge you have made.
Yes, the prayer is different, Lordship. But now, since he is retiring shortly, so I pray that it may be finalized, Lordship, basing upon this panel itself, Lordship, because already once that exercise was undertaken and they themselves initiated a fresh selection process amongst those candidates who were eligible and who participated in that interview, Lordship. So since my name is there in this panel.
Yes, Mr. Datta.
Lordship, in this case, Lordship, third question was before your Lordship in earlier paper. That petitioner has participated earlier and it was said by the High Court and directed for phase appointment, phase selection. In phase selection, he stood in third position, Lordship. His now condition is that as first and second is no one in service now. So this selection process may be finalized so that he can get selected. But the stand of the government is that this selection was held prior to amending of 2018 rule, Lordship. Now, Lordship, before finalization of selection process, new rule has come. And government has decided to cancel those earlier selection process and sought a permission from the Honorable Court to go for a fresh selection as per the new amended rule, Lordship. In this case, Lordship, on the last occasion, Lordship.
No. Whether any affidavit was filed by the government?
Affidavit, Lordship.
Affidavit dated?
Page 52, we have made categorical listing on that one, Lordship.
52 of this.
Lordship. Affidavit of question start from page 47, Lordship. Paragraph 7. Lordship, got it?
Paragraph 7. Yes.
Lordship, may I note that the deponent begs to state that the process of selection of regular principal of National Higher Secondary School Lamding was made by following Assam Secondary Education Provincialized Service 2003 as amended 2000. However, prior to finalization of the selection procedure, new rule that is Assam Secondary Education Provincialization Service 2018 came into force. So far as the matter is being submitted before the Honorable Court, and moreover, the process of selection of regular principal in other provincialized higher secondary school has been initiated as per new sets of rules. The Assam Secondary Education Provincialization 2018. Therefore, your deponent humbly prays before the Honorable Court to allow the deponent to withdraw the earlier selection process for the post of regular principal of National Higher Secondary School Nagaon, had advertisement number showing and further allow the deponent to initiate fresh process to appoint regular principal of National Higher Secondary School Nagaon as per existing service rule, Lordship. In this regard, Lordship, the power of the government to cancel the earlier selection process and to initiate the fresh as per amended rule has been dealt with in the Honorable Supreme Court in 1994 at 683 151, Lordship. Paragraph 4, Lordship, important. 4 and 5, Lordship. I may read, Lordship. Lordship, for equipment of the post of Inspector Department of Weight and Measure in the state of MP, an advertisement was issued on 27/7/1987 calling for application from eligible candidate. The qualification prescribed for eligibility was degree in arts and commerce or science or engineering or diploma in engineering. It was appeared that written examination were held and results were declared on 1989. Thereafter, the board issued interview cards to the successful candidate. In the meanwhile, the government amended the rule of MP Standard of Weights and Measurement Enforcement of 1989 in consultation with the Government of India and Public Service Commission and alter the eligibility qualification for appointment to those schools by presenting degree in science with physics as a subject or degree of engineering or technology or diploma in engineering. The respondents challenged the amended rule on the ground that having issued the notification for filling of the post of inspector with degree of arts and commerce, the state had to proceed with the equipment only as per qualification prescribed in the notification, and the subsequent amendment to the rule should not stand in the way of equipment board to consider the claim of on the basis of the marks secured in the examination and also interview to be held. In other words, the amended rule have no retrospective operation. This contention found favor with the tribunal and accordingly the tribunal allowed the application. It is not in dispute that the statutory rule have been made introducing degree in science and engineering or diploma in technology as qualification for recruitment to the post of inspector of weights and measures. It is settled law that the state has got power to prescribe qualification for recruitment. Here is a case that pursuant to amended rule, the government has withdrawn the earlier notification and want to proceed with the recruitment afresh. It is not a case of any accrued right. The candidate who had appeared in the examination and passed the written examination had only legitimate expectation to be considered for the claim according to the rules then involved. The amended rule have only prospective operation. The government is entitled to conduct selection in accordance with the changed rule and mark final recruitment. Obviously, no candidate acquired any vested right against the state. Therefore, state is entitled to withdraw the notification by which it has previously notified recruitment and issue fresh notification in regard to the basis of the amended rule also. So my case is equally covered, Lordship. The here, Lordship, he only came, his name only come in the interview, that too in a third position, not in the first or the second. So he has not get any vested right to be appointed, Lordship. His selection is subject to the decision of the government, and the government has taken a policy decision to withdraw the earlier selection and to conduct a fresh selection as per new system. So that in that view of the matter, the writ petitioner has no claim in this regard, and his writ petition may be dismissed, Lordship, and the government may be allowed to proceed the selection as per new amended to 2018, Lordship.
Yes, Sarma?
Lordship, there is already a direction in favor in the earliest litigation, Lordship, to continue with the selection and finalize it, Lordship. So it was, although it was not filed by me, but then that direction is still there, Lordship.
Where is that judgment?
Lordship, it's page 23, Lordship.
23. Okay, Mr. Sarma, we will resume after 5 minutes.
Lordship.
Mr. Sarma, you are referring to one
Lordship,
order.
Page 23, Lordship.
23.
Page 23, paragraph 18. Lordship, in the present case also, the issue relating to the appointment of regular principal in said National HS School, Lambding pursuant to the advertisement dated 21/6/2016, for which interview was held on 14/12/2016, is pending before the State Selection Board for its consideration, and the respondents in the Secondary Education Department is yet to take a decision in that regard. And further, the representations of the petitioner filed before the respondent authority are yet to be disposed of. Now, Lordship, paragraph 21, Lordship. Considering the above, it is observed that the concerned State Selection Board and the government in the Secondary Education Department, that is the official respondents hearing, shall comply with the provisions of the relevant provisions of the Assam Secondary Education Provincialized Service Rules 2003 as amended, and the office memorandum of the state government in the Secondary Education Department dated 6/6/2014, as well as the order of the Director of Secondary Education Assam dated 23/2016 in proper perspective as noted above, before finalizing the selection to the post of principal in National Higher Secondary School, Lambding, in pursuance to the advertisement dated 21/6/2016. So, Lordship, it was to be finalized by that order also, Lordship. And
Before finalization, what is used before finalization?
what had happened in
Not
my case is, Lordship, the government, although in their affidavit at paragraph 7 has stated that I'm reading paragraph 7 once again, Lordship. It's at page 52.
Page number?
Page number 52, Lordship, paragraph 7. that your deponent beg to states that the process of selection of regular principal of National Higher Secondary School Lamding was made by following the Assam Secondary Education Provincialized Service Rules 2003 as amended in 2012. However, prior to finalizing the selection procedure, the new rules, that is the Assam Secondary Education Provincialized School Service Rules 2018, came into force. So far as the matter is being subjudiced before the Honorable Court, and moreover, the process of selection of regular principal in other provincialized higher secondary schools has been initiated as per new set of rules. That is the Assam Secondary Education Provincialized School Service Rules 2018 as amended in 2021. Therefore, your deponent humbly prays before the Honorable Court to allow the deponent to withdraw the earlier selection process for the post of regular principal of National Higher Secondary School, Nagaon, by advertisement number 21/6/2016, and further allow the deponent to initiate fresh process to appoint regular principal in National Higher Secondary School, Nagaon, as per existing service rule. Lordship, herein the selection process was not cancelled at all, Lordship. The government did not take any step, or order was not first cancelled.
No, they have sought for permission.
Yes, Lordship, that's what. They have simply said that the other selection process of regular principal in the other provincialized schools are made as per the new set of rules. So therefore, they may be allowed to withdraw the earlier selection process, and the new selection is to be initiated in terms of the new rules. Now, the judgment that my friend cited, Lordship, herein, in that judgment, Lordship, the selection was cancelled by themselves, Lordship. They cancelled the selection process, and thereafter that was put to challenge, Lordship, that cancellation, Lordship. So in my case, that has not been cancelled by the government till now.
No, in that case, cancellation was allowed by the higher Supreme Court.
Yes. Yes, Lordship, cancellation was allowed. Now, I'll refer to a case, Lordship, wherein cancellation has not been allowed, Lordship. Now, my case is different from that, Lordship. Why I'm saying? Because they have not passed any order cancelling the selection process, Lordship. Me too, brother. Tripura selection, me too. Lordship, in this case, there was a new selection policy brought in by Tripura government, Lordship, with the change of the government.
Which is the relevant paragraph?
Lordship, paragraph 52 is relevant.
52.
52. The facts are like this, Lordship. Herein, there was a selection process, and in that, not only one selection, Lordship, there were many selection processes. A new selection policy was introduced by the new government, and they sought for cancellation of the recruitment process initiated by the earlier government, Lordship. That was put to challenge in this set of cases, Lordship. And at paragraph 52, it was held that that is not possible, Lordship. That is not permissible, Lordship. Paragraph 52, the grounds were that, I'm reading in paragraph 52. In the present case, on the strength of a general policy decision of the state, an ongoing recruitment process was first put in abeyance and then cancelled, it has been derailed with the intention to implement NRP. NRP here refers to new recruitment policy. When the recruitment has already reached the stage of preparation of the merit list, the very application of NRP to the ongoing process is illegal on 3 counts. Firstly, because it is an executive instruction, and in the absence of any amendment to the Tripura Service Rules Act and the Tripura Service Rules, recruitment rules.
Decision will never help you, because here they have amended new rule. No, they have brought in new rule.
Yes, Lordship, that first point would
Here
not apply.
it was an executive instruction only, which cannot in the Supreme Court case.
No, but herein my recruitment was not cancelled at all, Lordship. That's what I'm pointing out, Lordship. They cancelled that recruitment process, but in this case, it has not been cancelled, Lordship. The secondly, because the application of NRP to the ongoing recruitment process would amount to changing the rules of the game after the game has already begun. That is, the recruitment process has commenced. Thirdly, As per clause 2 of NRP, the recommendation to a police interview of grade D post would only apply prospectively, and it would mean to apply in the recruitment process wherein the interview has already taken place. So, Lordship, my basic submission is that this paragraph 52 is not required to be applied in my case because they did not cancel it, Lordship. And this, the judgment that my friend referred to is not applicable in my case because they did not cancel it, Lordship. And with regard to reasonable expectation, I am referring to paragraph 60 and 61, Lordship, of this judgment. From the discussions made herein above and in the facts of this case, the appellants have participated in the process of recruitment conducted in furtherance to the provisions of TSR Act and TSR rules. Undisputably, they found place in the panel of selection. It was only at the stage of character verification the process was kept in abeyance, later cancelled in terms of NRP, which could not have been made applicable to the ongoing recruitment process there. The application of the NRP to the ongoing recruitment process for the post of enrolled followers in Tripura State Rifles was not in public interest. Therefore, the appellants do have a legitimate expectation on completion of recruitment process in a fair and non-arbitrary manner. The recruitment process should be concluded fairly as per TSR Act and TSR rules, and the candidates may be appointed if they are found to be meritorious. As such, issue number 3 is answered accordingly. Number 61, in view of the discussions made herein above, we allow this batch of appeals setting aside the impugned judgment passed by the High Court. As a consequence, the repetitions of the appellants are allowed quashing abeyance memorandum dated so-and-so and cancellation memorandum dated so-and-so, insofar as their application to the recruitment process for the post of enrolled followers in Tripura Service Rifles is concerned. It is further directed that the recruitment process for the process of enrolled followers in Tripura State Rifles shall now be finalized and completed by the respondents following the provisions of TSR Act and TSR rules within a period of 2 months, pending application if any shall stand disposed of. So that was the direction passed. In my case, since there was no cancellation of the selection process, Lordship, I pray that paragraph 52 need not be applied. And this reasonable expectation which this honorable Supreme Court noted, Lordship, that is also applicable in my case, Lordship. That may be taken care of.
So in your application, your pair is number 1 is to set aside the annexure 4.
Lordship. That was there at that point of time, Lordship, because I was empaneled and I was in the panel, Lordship. I secured the first position, Lordship. And
now you are not pursuing this pair.
No, Lordship. Since I'll retire shortly in November, Lordship, let this exercise be completed within a specific time frame, Lordship.
So you are not pursuing this pair number 1?
No, Lordship.
Then second one?
This
second one is there.
This is also not there, Lordship, because the government passed a notification in 2019. It's at page 27, whereby this one was superseded, Lordship. Page 27.
This annexure is no longer there.
Lordship, that was put to challenge earlier, but subsequent this notification came and actions were taken in terms of this, Lordship. So this notification basically validates the selection process which was undertaken by the.
Now you are hammering upon this pair number 3.
Yes, Lordship. Oh, I couldn't. It will.
Mr. Nandi, you are not in this petition. WBC number 4225 of 2019.
I'm there for this number 5. Selection of-
Oh, school selection committee. Okay.
If this writ petition is come through and the annexes annexed to this writ petition, shows that it is devoid of any merit and it is liable to be dismissed.
Liable to be dismissed.
Yes.
Okay.
Because it is the annexure number 4 itself says that the selection process through which the petitioner was selected, that itself is in violation of the mandatory rules. And regarding that, there is no whisper. And they have annexed the copy of the lordship kindly peruse the judgment of this honorable court passed in WPC number 1296 that has been made as annexure number 2. Here also, the lordship of this honorable court has categorically held that the selection process is in total violation of the principle of law and the rules. In view of that, it is their own documents, annexure number 2 of the petitioner. See, in view of that, where is the stand for the petitioner to come up with any prayer? This once we have reached for this, that let as per the direction given by the authority, education, by the this thing by the joint secretary of education department, that is annexure number 4, has directed to go for the fresh selection because the earlier school selection committee was not in consonance with the rules. And assistant teacher has been appointed as one of the selection member of principal. That itself is a wrong thing. And our own High Court, as per there in this writ petition, the annexure number 2, as well as the annexure number 4 itself goes to the root of the writ petition, and this writ petition is liable to be dismissed. In addition to what my learned friend has submitted, that the rule has been changed, there is nothing wrong. Yes, once the rule has been changed and modified, as per that the new selection, new interview is to be called for.
No, you say the new rule has no prospective effect. The selection process was initiated while the earlier rule was in place.
Yes. So, at that time.
So, which rule will govern his case?
My lord, that very school selection committee, that itself was illegal. And it has been held by this honorable court also by their own annexure number 2. Itself shows that that was an illegal. And the honorable court has said that to go for the fresh selection after forming the proper school selection committee. It is the mandate of.
No, that's all right. Thereafter, new committee was formed. New selection committee was formed.
No, thereafter he has challenged this. He has come up with this.
Okay.
This writ petition has been filed. By challenging that, no, why this, if lordship kindly peruse their annexure number 5, that the school selection, school has failed, the school selection committee for interview of 23/6/2019, that has been challenged. That is the annexure number 5 of this writ petition.
No, now he has not been pursuing this annexure 5.
Lordship, yes, I filed a rejoinder subsequent to the filing of the affidavit in opposition by the department. Therein, this prayer has been made with, since these developments have taken place during the pendency of this writ petition. So therein, in reply to that paragraph 7, I have categorically stated that the selection may be what is logical and lordship. So that rejoinder, that paragraph would cover my case, lordship.
That rejoinder is at page number?
Page 74, lordship, paragraph 6.
74, paragraph number 6.
Rejoinder has been provided to us, madam.
Paragraph number?
Paragraph number 6, Lordship. That with
You have
regard,
not furnished copy of this affidavit to him?
No, we have not been provided with any copy.
I am not sure, Lordship, about whether he has been given or not, but otherwise I could not have filed it, Lordship, if I did not provide him a copy.
They might have provided to the state, but we have not been provided.
It's against the affidavit filed by the state only, Lordship. This rejoinder is again a reply to the objection filed by the state, Lordship. Paragraph 6, I am reading. That which, page 74, paragraph 6, that with regard to the statements made in paragraph 7 of the affidavit in opposition under reply, your deponent denies the same and states that the government considered the aspect with regard to the selection and appointment of principal at National Higher Secondary School from amongst those candidates who applied and participated earlier in the communication dated 8/5/2019. The process undertaken thereafter was as per provisions referred to in the said communication and need not be interfered with. The petitioner has got reasonable expectation to get selected and appointed as principal prior to his retirement. It is pertinent to mention herein that the other two candidates, namely Sudip Datta, in charge principal, and Mrs. Ratna Datta, retired from service on so and so respectively. Under the said circumstances, withdrawal of the earlier selection process and initiation of fresh selection process just prior to petitioner's retirement would greatly prejudice it. Therefore, the said selection process may be completed by forwarding the panel of 3 candidates by appearing in the statement prepared by the school selection committee dated so or 14/12/2016 or 23/6/2019 to the.
Okay.
So that was their, Lordship.
Do you have a copy of the same?
At present, I do not have it, Lordship, but I can
Can
give
you
him.
furnish a copy to him?
Yes.
We will list the matter on Thursday then,
Coming Thursday.
or day after tomorrow? Because this matter is pending.
Let it be. Or this week. Day after tomorrow.
Because this writ petition is of 2019.
Yes, my lord, I am.
So, and the applicant is also going to retire in the month of November.
Oh.
Only few months are there.
I can serve him now itself, Lordship. I will get it, Lordship, and give it to him. And
Mr. Yes, Aloma, you are here for the other matter.
Yes.
Okay. So, heard Mr. MP Sharma, learned counsel for the appellant, and Mr. Nandi for the respondent number 5. Respondent number 5. Mr. Dotto for respondent number
1, 3, 4.
1 and 2.
1.
1 and 2. 3. And 4 also. 4. 1, 2, 3, and 4. Heard in part, list the matter on Wednesday.
Lordship.
Wednesday. No, in the in item number 3. You are in 3. Okay, we'll take it up separately now. Here you are the petitioner.
No, my rank is 5 mile.
So, Mr. Sharma, why two petitioner is same in both the petition?
Yes, Lordship.
Here you were challenging?
Lordship, his selection in another school as principal. It was by the same order by which the government recommended him as well as me to different schools as principals, Lordship. And that order is an issue in both the writ petitions, Lordship. So these were tagged together in view of that, Lordship. So now since the schools are different, Lordship, these can be segregated otherwise, Lordship. If
My lord, this is completely different selection, different school, my lord. Only petitioner is the same. And issue is also same, my lord, but different, my lord. Here, my lord, regarding the marks obtained by the petitioner and the respondent was 5, my lord. That is in issue, my lord. And the inquiry was conducted, my lord.
So in this method, Abdul Rob, respondent number 5 was selected.
Yes, my lord.
And his selection is being challenged by the petitioner.
Yes, my lord. I am appointed, but I am watching, my lord. 19, my lord. Prior to that, in 2017, I was also appointed, my lord, but that appointment was kept in abeyance, my lord. And thereafter, an inquiry was conducted, my lord.
Yes.
And after that inquiry, the marks, both the petitioner and me, my lord, marks are same. But the state, when the inquiry report was placed before the state selection board, my lord, they have given me more marks, my lord. Inquiry officer stated that the marks are same, but the state selection committee given more marks to me. But he has
No,
considered
the question is whether state selection board can give more marks to you.
yes, my lord, it is not the authority of the inquiry officer to give marks, my lord. After the inquiry, the inquiry report was placed before the state selection board, my lord. They have recommended me and
No, whether the state selection board can award mark to you under the rules.
my lord, not award, my lord. This is corrected marks, my lord. They have
Corrected.
corrected the school selection board's marks.
Lordship,
Earlier marks were given by
School selection board, my lord.
school selection
Yes,
board.
then it was inquired, my lord, and it was only in respect of the so it is, my lord, completely separate issue, my lord. Sorry.
Okay, Mr. Sharma, you argue.
Lordship, at Annexer 9 of this case, Lordship, 430,
Here
page
in
30.
this petition, you are challenging annexer number 11.
Yes, Lordship.
Annexer number 11 is the appointment order of the respondent number 5.
Yes, Lordship.
Okay.
Now, at Annexer 9, page 30, Lordship, he came up before this court seeking appointment, Lordship, to the post against which he was selected, Lordship. The respondents took a stand therein, Lordship. Page 30, has your Lordship got it?
Page?
Page 30. The state respondents have filed the IA number so and so for modification of the interim order passed on so and so in the W.
You are not in this matter.
Not required my mistake in other I change my other.
Yes. Okay.
Lordship,
Who will appear, Mr. Datta? In this matter, who will represent the state? You Sharma. Okay. Okay. Yes.
I'm reading from the beginning. The state respondents have filed the IA number so and so for modification of the interim order passed on so and so in WPC number so and so. Under this interim order, the court directed that the writ petitioner as the recommended person should be allowed to join as the principal of Abdul Hasib Higher Secondary School, Hojai. The projection in the state's application is that the petitioner was awarded undeserved 0.5 marks in the leadership skill segment on the basis of incorrect information on the number of successful HSSLC students of the school. If the correct figures are taken, the petitioner is entitled to only 3 marks in the leadership skills segment, whereas he was awarded 3.5 marks. Number 3, the above mistake in awarding excess marks has led to a peculiar situation inasmuch as the petitioner would actually be entitled to 11 marks out of 15, and this is also also to total score of the other applicant SR Pal. That is the petitioner here. The Joint Director of Secondary Education in her inquiry found that Abdul Rab and SR Pal could score the same 11 marks as per the evaluation criteria. Hence, the departmental authorities are at a dilemma as to who between the two should be posted as regular principal of the school. That is why the appointment was kept in abeyance under the impugned order dated so and so. And now this day vacating application has been filed by the authorities. However, Dr. B. Ahmed Al Lanet, counsel for the respondent lead petitioner, submits that conducting an inquiry on the selection process was totally uncalled for, and accordingly he prays for time to file objection to IA. The counsels point out the contempt petition number so and so was filed in the meantime in respect of the court's interim order dated so and so. In view of the above, the petitioner is allowed 2 weeks time to file. So that was done, Lordship. But this observation at paragraph 2 of this order, with regard to the stand of the department that he is entitled to 3 marks only, and the reason for filing the IA was noted, Lordship. So it was 3 or 3.5, Lordship, that thing was done by the department, Lordship. Later on, that was changed to 3.5, Lordship. So that 3.5, Lordship will find in the inquiry report, Lordship. So basically what had happened, Lordship, some students appeared in the school he was working against, and that number of students which was shown to have appeared by the principal, that inquiry report shows that, Lordship, the principal of that school gave the number wrongly, Lordship. And in that same school, Lordship, Abdul Rab was working, Lordship. And now whether that was a foul play or not, that is not known, Lordship. But then due to that increase in the number of the students, Lordship, the number changed, Lordship. And it was changed from 3.0 to 3.5. Because of that, he got 0.5 more marks more than me, and he was selected as principal of this school, Lordship. And that was put to challenge, Lordship. Now, it is the department who is to take a stand as to whether how they could change from 3.0 to 3.5 by instituting an inquiry, Lordship. And if that obviously is in violation of the rules, Lordship. And if the stand of the state that the inquiry conducted to award 0.5 marks more to him was right, then it has to be tested in terms of the provisions of these rules, Lordship. And if it passes, then obviously he will succeed, Lordship, and otherwise I will succeed, Lordship. That's the case, Lordship.
Okay. Yes, so what is your stand?
Can we go to the annexer method, 15 method, affidavit method?
Annexer?
Annexer 15 method in internal page 34 method. This is the inquiry report method. Here, my lord, both the repetition and respondent number 5, my lord, are shown same marks, my lord. Page 37, my lord.
Yes.
The inquiry officer has taken only the science stream method in calculation method, and in calculating the science stream method, he found the marks are same method. Thereafter, this inquiry report was placed before the next page method, another 16 method.
437.
40 method, state selection mode method, and another.
No. In this affidavit, you are referring to paragraph number?
My lord, another 15 and 16, my lord.
Annexure 15 and 16, it is not there.
Lordship at page 78 probably, Lordship.
78.
In my application.
Annexure 11 is the order.
Lordship, it's an inquiry report. This is the one, Lord.
Page number?
It's page 34 when it was not running number, Lordship, but then it was changed to 78 subsequently, Lordship. If running number is. Annexure 15 page 34 asile agote.
Annexure
34 asile. Tar pisot running number dile 78 hol.
Yes, section below peak boarded 31 was in the 31 100.
January.
Annexure number?
Annexure number 15, my lord. Right.
Yes, inquiry report.
Inquiry
Okay.
report. Here, my lord, it is shown and my lord page, running page, my lord, in my affidavit 37, my lord. Here it is shown the marks are equal, my lord. After calculating the only science stream, my lord. Whereas in higher secondary school, both arts and science stream are to be calculated, my lord. And then, my lord, next annexure 16, my lord, next page, my lord. This is the order passed from the director of secondary education, my lord. Here, my lord, both the streams are taken together, my lord, in calculating the percentage, pass percentage, my lord, of the students. Here, my lord, I have given 3.1 marks in leadership skill and in total, my lord, 11.1 marks. And the repetition I given, my lord, only 11 marks. He has, my lord, concealed this annexure, my lord, this order, my lord, of the 19th February, my lord. This order was not annexed, my lord. He has claimed that his marks are equal.
Okay.
But this was not reflected, my lord. I secured more marks than him, my lord.
As per this order.
Yes, my lord, by this. Thereafter, my lord, the state board recommendation is there, my lord. And annexure 17, my lord. I was recommended, my lord, in serial number 2, my lord. Internal page 41, my lord.
Yes.
Abdul Asif in school. So in the right column, my lord, Abdul Rob, that is response number 5, recommended as regular principal of Abdul Asif HS school, my lord. This is the state selection board, my lord. Recommended me, my lord. Thereafter, my lord, I was appointed, my lord. Again.
Okay. Whether any stay order is operating?
No, my lord, there is no stay order.
You are working as
Yes, my
principal.
lord, I am working.
Lordship, page 79, this was taken into consideration. The second page of
No,
the inquiry.
Mr. Sharma, let him complete.
Lordship.
My lord, another thing is raised my lord, the repetition or any reply to my affidavit, my lord. But the rejoinder, my lord. Let us start by the repetition, my lord. Here, my lord, mark in calculation. He has submitted my lord some RTA reports, my lord.
Page number?
RTA reports, my lord.
Page number?
Page 105, my lord. 104 and 105, my lord.
One zero four and five are part of this affidavit in reply.
Yes, my lord. This is marking, my lord. Yes, my lord. 106 is there, my lord. In his reply, my lord.
Yes, 106.
Here, my lord. This is the my lord records he has obtained by my lord by RTA application, my lord. Here, my lord, is shown the total number of students appeared. Art stream, my lord. At my lord, serial number 1, my lord. Total number of students appeared 88. Here it is shown as 88, but this is not correct, my lord. Here it should be 83, my lord. Though 5 students, my lord, they have applied, my lord, they have not appeared in the examination, my lord. This is the record, my lord. This is the record. Yeah, my lord, 5 students have not appeared, my lord, because they have applied for the examination, my lord, but they have not appeared, my lord. And that is why this is calculated 83, my lord. Both in the inquiry officer report as well as the order by the state selection board. In the inquiry report also, my lord, this figure was shown 83. And in the order dated, my lord, 12 February 2019, whereby I have recommended, my lord, this figure was stated to be 83, my lord, not 88, my lord. So, my lord, I have secured more marks than him, my lord, and as such, I am appointed, my lord. And I am continuing since 2019, my lord.
Okay. Yes, Mr. Sharma, what is your reply?
Lordship. Lordship will come to page 98, paragraph 5 of my reply, Lordship.
Yes.
Paragraph 5. With regard to the statements made in paragraph 5, 6, 7, and 8 of the affidavit in opposition, your deponent denies the same and reiterates the statements made in paragraph so and so of the connected with petition. The marks allotted against leadership skills in conformity to the office memorandum dated 23/6/2016 is 5. The marking is based upon result of institution in which the candidate served in the last year and the current year. The state respondents preferred IA number so and so in WPC so and by the order dated so and so in WPC so and so. It was clearly reflected that the state respondent took a stand that Abdul Rauf was entitled to 3 out of 5 and not 3.5 out of 5. In the first re-scrutiny by the Joint Director of Secondary Education dated so and so, the result of the science stream of the school is taken into account as respondent number 5 is a subject teacher in the chemistry. In this regard, the Joint Director in her inquiry report clearly mentioned that in 2015, students appeared in science stream was 30, not 23, and passed 13. Pass percentage was 43.33, not 56.50. Similarly, in the scrutiny by the State Selection Board dated 12/2/2019, both arts and science streams are taken into account to calculate the results of the school of respondent number 5 so that Mr. Abdul Rob can be appointed as regular principal of Abdul Hasib HS School Hojai. In this regard, State Selection Board had in a biased manner shown that the students appeared in art streams in 2016 was 83, not 88. Pass percentage was 73.49, not 69.13. The calculation behind entitlement of 3 marks is as follows. In 2015, the school wherein Abdul Rob taught, 97 students appeared from art stream and 48 students passed. The pass percentage was 49.48 arts. Similarly, in the science stream, 30 students appeared and 13 students passed. The pass percentage was 43.33. Similarly, in 2016, the school wherein Abdul Rob taught, 88 students appeared from art stream and 61 students passed. The pass percentage was 69.13 arts. In science stream, 14 students appeared and 11 students passed. The pass percentage was 78.57. Upon calculation, Lordship, in the next phase, it turns out that the marks to be allotted for that leadership skill was 3.0085, Lordship. The next paragraph, Lordship. The petitioner mark is 4.55, which is ignored to round it to 4.6 against leadership skill. In the said inquiry report dated 28/7/2017, the number of students appearing from arts stream from the school of respondent number 5 was taken as 83 instead of 88. If the number of students were 88, the respondent number 5 was entitled to 3.085 and not 3.1 marks against leadership skill. On the other hand, the petitioner marks is 4.55 against leadership skill. The order dated 12/2/2019 rounding of the marks allotted in favor of respondent number 5 against leadership skill from 3.0085 to 3.1 is non-est in the eye of law. The subsequent recommendation in favor of respondent number 5 by letter number so-and-so dated so-and-so is bad in law. Consequently, the appointment order dated 8/3/2019 is bad in law and the same needs to be set aside and quashed for the ends of justice by appointing the petitioner as regular principal of Abdul Hasib HS School with effect from 8/3/2019. Now, I would also rely upon paragraph 7, Lordship, of this affidavit in reply, Lordship. Herein also the facts that I'm reading it, Lordship. That with regard to statement made in paragraph 10 of the affidavit in opposition under reply, your deponent denies the same and states that under the provisions of the Assam Secondary Education Provincialization Service Rules 2003 pertaining to the selection of principal, the power to receive the scrutiny of application, this is important, is vested with the school selection committee under Rule 13(2) and not otherwise. The school selection committee received and scrutinized the application of the petitioner as well as the respondent number 5. The respondent number 5 was a teacher of Abdul Hasib HS School and he preferred application for the post of principal in the same school itself. The application preferred by the respondent number 5 was defective inasmuch as the number of students appeared and passed from the school of respondent number 5 was wrong. The said misinformation was deliberate and willful, designed only to secure the post of principal by hook or crook. It is not acceptable that the teacher does not know the number of students in the school and the number of students passed. The blame cannot be shifted to the principal of the school inasmuch as the respondent number 5 was a teacher of the in Abdul Hasib HS School and he could have influenced the selection by manipulation. The guidelines dated 23/6/2016 under the heading Leadership Skills provides the candidate will produce the result sheet duly certified by the principal of the institution where she is presently serving, meaning thereby the candidate will produce the result sheet and not the principal. The moment a fault is detected in the application, the same gets cancelled and it would not be processed any further. In the present case, the application submitted by the respondent number 5 was not cancelled, but it was re-scrutinized twice by the Joint Director of Secondary Education on 28/7/2018 and the State Selection Board on 12/2/2019 in violation of the provisions of the Assam Secondary Education Provincialization Service Rules 2003. The Joint Director of Secondary Education as well as the State Selection Board exceeded its powers and re-scrutinized the application of the respondent number 5. Thereafter, the respondent number 5 came to be appointed as principal of Abdul Hasif Higher Secondary School by the order dated so and so. The order dated 8/3/2019 ipso facto supports violation of the provisions of the Assam Secondary Education Provincialization Service Rules 2003 by the authorities involved in the state selection process in the manner aforesaid, and the same cannot be allowed to continue. As such, the order dated 8/3/2019 is bad in law and needs to be
Whether
taken.
the guidelines of awarding mark is placed on record.
Yes, Lordship.
Page number?
It's at page 15, Lordship.
Page number?
15.
So which number is counted? Which number of student is counted who have took admission or who have appeared in the examination?
Both are counted. The number of past students the number of past students out of the total number of appeared students, Lordship, that has the percentage is counted, Lord. And
So out of 83 and 88, 83 is the students who have passed the examination. Then 88 is the number of students who have appeared in the who have taken the admission, but they have not appeared in the examination. Not passed the examination.
Not appeared. 88 had applied for the examination, my lord.
Applied for, and they have not appeared.
83 is appeared. Out of 88, 5 was not appeared in the examination. So this appeared student is 83.
83.
Yes, ma'am.
Okay. You have mentioned the same figure in your affidavit?
Yes,
In your affidavit?
No, my lord, it is came out, my lord, after the reply submitted by the writ petitioner, my lord. So I have not found any reply to that matter.
So your submission is based upon these documents. These are not part of the record.
Yes, madam, this is not submitted.
Then can we take note of these documents?
I can file an additional affidavit.
Additional affidavit. Mr. Dotto, what is your stand here?
So I cannot go beyond that.
No, yes, that's all right. What is the stand of the director?
Paragraph 5 of notes, Lordship. That there is a mismatch found in the result statement of Abdul Hasif High Secondary School occurred the respondent number 1 by letter of so and so. Requested the deponent to inquire the matter at home Joint Director of Secondary Education and till then appointment of Abdul Roof as regular principal be kept at bench. So thereafter, by the order dated 21/7/17, passed in petition of 4304. The Honorable Court directed the departmental authority, the secondary education, to allow Abdul to join in the post of principal a school and subsequently filed order as so and so part in so the honorable court was pleased to stay the interim order as so and so till the next date. And there are contacted that the in partnership of government letter dated 28/6/17, the Joint Director of Secondary Education conducted an inquiry on the matter and submitted report to the government. On the later on, the State Selection Board reviewed the matter and passed the order, that is order 12 to 2019, recommending the name of Abdul for appointment of the post of regular principal of Abdul Hasef Higher Secondary School. As the response number 5 got 11.1 marks out of 15 marks and the petitioner has obtained 11 marks out of 15 marks. Lordship, it is on the basis of inquiry report, Lordship.
Inquiry report.
Inquiry report.
Okay. Alam,
My for BA degree was challenged also. Raised question about his BA degree. So, we can find out affidavit and clarify that his BA degree is recognized by the
his BA degree is valid. Valid. Okay.
we have also find out affidavit methodology for 11.
Okay. Mr. Barbuya, you want to file affidavit?
Yes, right.
Bringing on record these documents.
Yes.
Heard, Mr. MP Sharma, learned counsel for the petitioner, Mr. Dotto for the respondent number
124. Okay.
124, Mr. Barbuya for respondent number 5. Ken? Keuddin. Okay, sorry. Keuddin for the respondent number 5. And Mr. Alam for respondent number? Respondent number 8. Heard in part, list the matter when?
Petitioner
We will be able to 10. 10. List the matter on 10. In the meantime, Mr. Uddin shall file an affidavit bringing on record the result of SS final year examination 2016 of Abdul Hasib Higher Secondary School. Party assigned.
My lord, may I mention, my lord,
Yes.
that matter at item number 1, my lord, I was not available till August, my lord. My lords have put it today. There's no question of, my lords have once adjourned with consent on 8th of July, my lord. There's no question of preponing the matter. And there's no question of depositing contempt. We cannot deposit. We have to deposit where the decree in the main matter. We can't deposit in the contempt matter. My lord. So my lords have adjourned it to 14. Let it be heard on 14. My lord. I am with great difficulty I have joined. Otherwise, I was not free, my lords.
Okay.
Grateful.
No, Mr. Raju, you see on the other day, while mentioning the matter, you have submitted that the depositing the amount in the writ petition and the contempt petition is the same thing.
My lord, the depositing has to be in the writ petition. It can't be in the contempt petition, my lords. It can't be in the contempt petition.
No,
It has to be in the writ petition.
Mr. Raju, it was your version.
Yes, therefore,
It is
my
the same
version
thing.
is this. My version, I don't remember recollections. My lords are saying I might have said that, but I don't recollect. But if that is the version, it means contempt gets over. And even otherwise, I argued the contempt matter fully. And it was, my lord said it will be heard with the main matter. It was fully argued. The contempt was fully argued.
Mr. Raju, you see, we have, after completion of the argument in the contempt case,
yes,
almost 2 months elapsed. So you see, we have to pronounce the judgment within 3 months from the date of completion of the argument.
Yes.
So in that matter, we have passed one order that both the this writ petition and the contempt petition will be disposed of together. So
now my lords
you
may segregate it, my lords may separate it and pass an order on the contempt matter, my lords.
No, Mr. Raju, you see, both the matters are interrelated.
No, my lord, it's not in contempt. There is no contempt. That is separate. Contempt was only for not constituting the committee. At that time, when the contempt was filed, there was no award, there was no amount deposited, required to be deposited.
No, you see, that order, unless it is recalled, we cannot do this.
No, what order is required to be recalled, my lord? With great respect, my lord. The order of hearing both together may be recalled and contempt may be disposed of because I've argued contempt hasn't thoroughly and fully argued.
No, on the day of completion of argument in the contempt petition,
yes,
one order was passed that both the matter will be disposed of together.
So my lords may recall that order and say that contempt may be disposed of and order may be passed in this matter.
No, unless one of the party file an application for disposing of the same or recalling the order, can this court sumo to do this?
Always can do it, my lord. If my lords want me, I will file. But it is always court can always do it. In view of the direction of the Supreme Court, your lordship can say, since the Supreme Court has directed, I am separating the matters.
Yes, Mr. Das.
I'll just give a reply.
Well, may I leave, my lord? I have some urgent work. I came only for the mentioning. My colleague, Mr. Dyer, is there, my lords.
But I
I'm
am telling before Raju leaves, I just want to tell so that now he has left. My lord, there has been intention of doing this matter. From very beginning itself, your lordship has seen that contempt was taken up, your lordship has heard the matter, but with an observation that we will hear both the matter and dispose of. Now, 16th of February 2026, they have filed a writ petition before this Honorable Court. And the Honorable Court has kindly see, I don't want again to trouble the order of this court. Thereafter, we file affidavit immediately. Rejoinder, they took several dates to file rejoinder. Thereafter, rejoinder was filed. Thereafter, the matter was fixed on 3rd. Please look at see my 3rd, 3/6/2026 matter was filed. We were not aware of it. You know, whatever maybe it was mentioned. Now they want this matter to be done on 14th of July, which is an holiday. Now, all it is complete. What is the point of maintainability has to be argued first by us, not by them. They have filed a writ petition. They are saying it is maintainable. We are saying that it is not maintainable. I will show on the face of it. This is only for the purpose of circumventing the order that has been passed by the court on 10th of February 2026. Let me start my application for maintainability. Why it is not maintainable, my lord? Why this petition is not maintainable? My lord, after hearing your lordship, I'll take only 40 minutes to place before this court why this petition is not maintainable. Your lordship will be shocked in what manner they have filed this petition. Each and every petition I have looked into, every amendment that they have made. Your lordship will kindly what they are stating in the writ petition. Your lordship has passed the order on 10th of February 2026, 2025. The order was passed by this honorable court after going through it. Now what they are saying that you have to go back of 2018 and you denotify 2018. So what type? These all were before you. I have gone through each and every amendment, and in that amendment, your lordship will be shocked. It is their requisition which they invited to the government, and government, on looking into the perspective of the matter, has said this is a private land. This is 142 hectares of land. These are project affected family. This went to them. This went to NSPC official before award was passed in 2018. All the correspondence, my lord, letters are before the court, which is filed by the government also. And this, what your lordship will be shocked, what they are saying. They are saying no. These are all administrative communication. Does not amount to consent. You yourself in 2017, my lord, has written that yes, we want this 142 hectares of land, and they know that is a private land. And today you are coming up before this court of 60 and you saying.
That's my apologies, my lords. My learned senior friend is arguing on merits, my lords.
No, I will
Whereas
argue
the issues
because you are taking
circumvention
time
is
after time.
My lord,
Sorry
that
to
is
say,
squarely addressed in
Mr.
the
Nayak,
contempt
you are
petition, my
taking
lord.
time after time. I don't react in the court, but I have to react in this
No,
court.
it
I
is
have practiced 40
incorrect to
years.
say, my lords, we are
I don't
taking time,
react
my
in the
lords.
court.
We were
I
ready,
don't
we were
react.
ready with the matter, my
I
lords.
don't
After
react
this
with the
came
court.
on the last date, my lords, we were ready with the matter, my lords. It's only for listing of the matter, my lords.
My lord, 1 second, Mr. Nair, 1 second. What they have done, my lord, now they have filed an additional affidavit. Please see the additional affidavit. They are saying that we, along with the government, is hand in glove. Is this what they are trying to say? What they are trying to say? Please see the additional affidavit. Please see, my lord, what is their contention, and they are withdrawing it now. Why you made a statement? You want to withdraw it because we reacted to you want to withdraw it. Please see the additional affidavit. Please see it, my lord. Additional affidavit. Take on page 774.
My lords, all of this is on merits of the matter, my lords.
No, please.
An opposition on this, my lords.
Please see.
It is only for the purpose of fixing of a date, my lords. And this affidavit, my lords, we have only reacted.
Please see 775. Please see 775. Please see the 775. They have made a prayer. Allow this logic of it.
775.
Please 775. The initial affidavit has been filed by them. Recently they have filed. The initial affidavit in reply. And if your lordship is kind enough to take 718, my lord, page 718.
718 to দেখাই দিব thanks.
718 of the main case, 718. Please see, sir. 718. Please see 718. It is there. Rejoin there. It is the affidavit in reply. Lordship got it, final.
Paragraph number?
718, paragraph number 15.
Yes.
See, my lord, that the respondent number 4 being the authority that prepared and passed the impugn award, and the state of Arunachal Pradesh being the authority that approved the said award by letter dated 28/7/2025, share a direct and common financial interest with respondent number 5 to 13, inasmuch as the award confers enormous benefit, financial benefit on the private landowners at the direct cost of the NSPC, which is the government of India undertaking. These shared interests must be borne in mind when evaluating the forcefulness and predisposed approach with which respondent would defend the impugn award and resist NSP's challenge. The award must stand or fall on its own statutory validity, and the vigor of defense by passing authority cannot substitute for lawful foundation. Now please see para 17. What type of, my lord, stand they are taking? Please see 17. Then at page 719. The respondent number 4 has throughout its affidavit in opposition sought to characterize the impugn award as a product and consequence of the order dated 10.
That is for the state government to say, my
by
lords.
this court, as though the order, see, my lord, as though that order by directing a fresh award had thereby validated all components and all quantum embedded in the fresh award. This is fundamentally erroneous reading of the order and is untenable. This type, my lord, your order is as a product. This is what is as of a product and a consequence. And kindly see now, after what they have done, they have filed an affidavit, additional affidavit, they are withdrawing all this statement. So they made same statement in land management also. So that is connivance between us
My
and
lords,
between all
that is
private
for the
parties.
state government, my
Why-
lords,
why all this
unequivocally,
Why all this
unconditionally.
Or why different stand? Only for the purpose of circumventing.
There
these
is,
are the
there
four
is, there is no
landowners.
different stand. My lords, in our writ
These are-
petition, we have emphatically made
Why?
a statement, my lords,
My lord,
that this would amount to state.
Mr. Nair,
Please, my lords.
let Mr. Das complete first.
Yes.
My lords,
You will be,
my lords,
you
he
will
is
be given
arguing,
time.
my learned senior is arguing on merits, my lords. Today the matter is
No,
listed.
no,
only
not
in
arguing.
of
He
date,
has
my lord.
pointed out the stand taken by you in the additional affidavit.
What
Please,
I
my
am
lords.
saying, my lord.
So that
all
would
the
be
time-
decided
all the
along with the
time-
main matter, my lords.
No, all the time they are.
I have not taken any stand. I have withdrawn my stand, my lords.
Changing one after another stand, my lord. Changing one after another. My lord, trying to recollect why we are saying that it is not maintainable. If your lordship is seeing the writ petition, their writ petition, what stand they have taken, your lordship is shocked what stand they have
That
taken.
is on merits,
They
therefore
are,
I'm
they are
saying.
going. No, I am saying maintainability of the writ petition.
My
Please
lord,
hear
that,
me. My
if
lord,
it
I
is
will
only a question of
respectfully
circumvention of this honorable court's order, for that contempt proceedings have already been initiated. My lords have already reserved the judgment in that, my lords. My lords will give a finding whether it is a circumvention of the order or it is not, my lords. Or this is an independent proceedings, my lords. My learned senior friend, my lords, can you
I am
stop
arguing
us
the
from
matter.
using a challenge to
Mr.
an
Nair,
award, my lords?
Mr. Nair, I am just arguing the matter. I am just
Please,
listening.
therefore, I am requesting that the
Yes,
matter may be
please.
argued on the date fixed.
My lord, there is no stay of this award. There is no stay of the award. Is there any stay of the award? There is no stay of the award.
So we have deposited
Now,
before the
now,
court,
my
my lords.
lord,
The
they
amount is
doesn't want to argue
deposited.
this matter. They want to linger this matter up to month of July. That's what my lord was saying. If they doesn't want to pay, very well. Your lordship is under scrutiny of the contempt. Your lordship will decide. If you don't want to pay it now, very well. But please hear this, my lord. What I am requesting, my learned friend, that at least my maintainability point can be taken up by this court, whether this repetition is maintainable or not.
Well, that is for the
Well,
state
they
to
are
take, my lords.
circumventing.
The
Please
project
see.
affected families are not before, my lords.
If your lordship finds
What is the
that
interest
this
of the
particular
person whose land is
repetition
to be
not
acquired?
maintainable, end of the matter, my lord. Why they make us a party then? You make us a party and saying that you are not required in this case. They are making us a party. And they are making state.
Parties
No,
have
but
to
this
be
is not
made.
the way.
Whosoever is a party to an award is to be made, my lord.
What they are
Whether
saying,
the land is in excess of the
please,
required
Mr.
land.
Nair,
By my lords.
but this is a high court, this is not Supreme Court. We don't
I
argue.
understand, my lords.
One by
Therefore,
one
I am
we argue.
requesting,
Yes.
therefore, my lord, I am requesting, let the matter be placed on a date, my lords. We'll argue. We'll not take more than 1 hour. My lord, it's
Very
a
well.
legal
It
right
doesn't
to
take
challenge
1
an
hour.
award, my lord.
Nothing that like that, my lord. Your lordship, my lord, with great respect, with your lordship permission, can it be taken up tomorrow? We'll argue on the maintainability. Let my learned friend remain.
My lords,
Let
it
him
is
go
my
down.
petition. How can my learned
Yes.
senior friend argue? He's a
Maintainability.
even the state is not before the court saying that
No,
let
state is
them argue
there.
first.
State is there. Why I cannot argue? State
State
is
has
there.
to insist, my lords.
Yes, state will be, my lord, my information is that state is going to argue this matter on the maintainability point.
Because the award is by the state government, my lord. State government is the primary respondent, my lord. State government has to defend the award, my lord. State government is not saying anything, my lord. Whatever state government is to say,
They doesn't want that I should argue this matter. They doesn't want that, my lord. That's simple. They doesn't want that, and they are making me as a party in this case. And what they are saying that we don't have any locus. Now their whole case is that we don't have any locus. My lord will kindly see.
Okay, Mr. Nair.
Please, my lord.
Let us fix the matter tomorrow.
My
Let
lords,
Mr.
tomorrow
Das
learned
complete his
ASG
part.
would not be available, my lords. Therefore, we are requesting learned ASG actually mentioned before, my lords. He mentioned and thereafter 14 days was given, my lords.
Nair is there, Nair can take a note of it.
No, let Mr. Das complete his part.
Yes.
You can argue the matter later on.
My lords, so far as his part is concerned, my lords, my learned senior can always argue in counter, my lord. This is a point in counter, my lords. It is my petition. I have to open it, my lords. I have to say how the impugned award.
Since you are not ready, let him argue first.
No, my lords, he is a respondent, my lords. Even the state
Maybe
is not looking
he
forward,
has
my
the
lords.
right. He has also the right.
No, my lords, how can in my petition a private respondent can open a matter?
Can I say one thing? My learned friend, I'll give an answer to it. Can a maintainability cannot be argued? Your lordship can take the
My lords
maintainability. It
my
doesn't
lords
want
will hear me
maintainability
first
to be
to.
heard.
My lords will
If it is
hear me
maintainable,
first
we will
and
argue the
thereafter, my
matter.
lords will come to a finding
It's
whether
not very.
petition
No,
is or
Mr.
not.
Nair, you say first we have to decide the point of maintainability of your petition.
My lords, it cannot be my writ petition, my lords. I cannot be non-suited only on the ground of maintainability, my lords.
We will see
I
later
have
on.
to, I have to
We'll
argue
see.
I have to argue my matter in comprehensive way on merits as well as on maintainability, my lords. The state has to respond. State has come with a
No,
detailed.
that's all right.
application.
You have given more than 3 months time, but you failed to
Yes.
argue your case.
No, my lords, we were ready to argue the case, my lords,
No,
had that.
no, you are always ready, but
On the
always
past
come
date,
with
my
a
lords,
prayer
had
for
the list
adjournment.
been issued. My lord, list was issued in the morning, my lords, at 10:30 we were informed, my lords. The learned ASG took other assignment, my lords. We had reserved the matter for him only. We would have completed on that day, my lords. Now, my lords, because of that predicament, learned ASG had mentioned the matter, my lords had given the date, my lords. We have already stated, my lord, learned ASG is not available till 29th. After 29, my lords may keep it on any date, my lords. It will not take us more than 1 hour to argue our matter comprehensively on maintainability as well as on merits, my lord. It's a short matter, my lord. We did not labor much on any other point, my lord.
Once some starts, it starts, then they will automatically come, my lord. Let me start my case. Tomorrow, state is also going to argue
My
this
learned
matter.
senior is not a petitioner, my lords. Had my learned senior filed an independent petition, I would have agreed.
It is a
I would have not opened my mouth.
It is barred by res judicata. I am raising constructive res judicata.
That is the point which has to be raised in the counter, my son.
No, I have to raise it now. That your lordship will look into it whether it is maintainable. What type of case writ petition has been filed? Please look into it, my lord. I will go through all the pleadings what they have mentioned, my lord. What pleadings they
With
have
all due
mentioned.
respect
They are
and
going of 2018 notification where they want to denotify. And what they are saying, administrative action.
Okay, Mr. Nair.
Please, my lords.
Let Mr. Das start first.
My lords, I have to take instructions, my lord, because I have a supremely objection to this, my lords. It is my
Maybe
petition, my lords.
you may have objection, but the problem is that you always come with a prayer for adjournment.
No, my lords, that impression is not correct, my lords. We were always
No. Your conduct, Mr. Nair, your conduct shows the same.
My lords, only 2 dates we have taken time, my lords, because of certain exigencies which are explainable, my lords. Which are clearly explainable. On the last date, my lords, we were ready with the arguments, my lords. Had the list been issued on, my lords, we would have completed the argument at 2 o'clock, my lords. In fact, my lords, we had deferred our vacations only because of this matter, my lords. Only because of this matter, we had deferred our vacations, my lord, just to conclude it. Unfortunately, on last date, my lord, because of some administrative problem, my lord, the list could not come. Have it on any day after 29th, my lords. We will take only 1 hour, my lords. I don't know about the state.
Mr. Nair, you say after 29, this court will be closed on account of this summer vacation.
My lords, then have it on 14th itself, my lords, the prefixed date, my lords. My lords have not fixed any date, my lords. Today it is only for the purpose of taking instructions. My lords, I am saying so that I have to argue my matter. I have to open my matter, my lords.
But now, my lord, what my learned friend wants, they doesn't want to pay the amount. They doesn't want to hear this matter. They doesn't
My lords,
want
I have deposited in the court, my lords.
Yes, this is
I
what
am
they are
before my
trying to
lords.
do.
I am in hands of
This
my
is the
lords, my lords.
instruction they are getting it, my lord.
My
Not to
bona
pay the
fide cannot
amount.
be challenged.
Yes, you are saying not to pay the amount. Number two, you don't want this matter to be done.
My lords, if my learned senior friend want that I should not even move a petition, then that's another matter. It is my legal right to challenge an award, my lords. It's my legal right to challenge an award up till the apex court, my lords.
My lord,
My learned senior friend cannot say that I should not challenge it.
No, he's not saying that you cannot
My lords,
challenge
this
it,
is
but
exactly
you are
what my
challenging
learned senior
certain
friend
things
is saying.
which you
That
are
I should not even challenge an award, my lords. I should accept whatever is the award.
Kindly fix it tomorrow at 2 o'clock. I will address on this point, my lord.
Well, it is my petition. I'm only saying let it be fixed any date after 29th when learned ASG is there, my lords, or on the date when my lords have already fixed. It was fixed in the presence of learned ASG. He has to conduct the matter, my lords. He has to argue.
No,
I can say, my lords, may record my statement. I will not take more than 1 hour, my lords. In fact, 1 hour is also a very outer limit, my lords. We will not take more than 40 minutes in this matter.
My lord,
It's a very neat question of law. If
they can argue, my lord, let him take a note on it. Why is finding it difficult to take a note on it, my lord?
it is,
Take a note on it.
my lords, it is unheard of. In my petition, the private party wants to open the arguments, my lords. Unheard of.
But you don't want to do it. That's also unheard of.
You try to. My lords, may kindly see the order. I don't want to. My lords,
Okay.
I am addressing my lords. I don't want
Mr.
to.
Das, let it be on 13th of July.
13.
Yes,
My lords,
item number 1.
my
Item
lords,
number
13,
1.
there is a difficulty with ASG. My lords, 14, therefore.
This cycle will close or not. So there cannot be any link from, I think.
No. Arunachal, they can appear from VC.
No, I think court is closed, my lord. No registry will be there. So I think this matter comes up from there itself. Link has to be, I don't know, my lord, subject to, if your lordship feels, then there is absolutely no problem, my lord. But I think there will be some difficulty, my lord, because this state council will also not be there, my lord, till 28, 2019, 19.
Miss Wang Mao, if we fix the matter on 14th of July,
14th
Can
of July,
you-
my lord, there is a holiday, my lord.
holiday,
Holiday, yes, my lord, here in Itanagar bench, my lord.
okay. So when the bench will open?
It will open on 20, my lord.
20.
But what I was suggesting, my lord is saying that how can you open up the case? State also has. filed
Otherwise,
an
my lord,
application for
July
They
1,
have
2,
also
3, my
filed
lord,
an
any day.
That would be feasible if it is in first week of July, my lords. In fact, we will try and
Yes, my 1, 2, 3, my lord.
physically come before my lords and address my lords. Because the
My
Supreme
lord,
Court is also on
I
vacation,
think
my
my
lords.
lord has to take a rest also. It's not that all. Because
No,
our
Mr. Nair, you say, first July, 2nd July, 3rd July, these are holidays.
The learned courtmaster indicated that 1st, 2nd, 3rd July can be. The learned
Yes,
courtmaster.
my lord, it's not holiday here, my lord. 1st, 2nd, 3rd July is court working day, my lord.
In
Therefore, my
Itanagar
lords, I
bench.
make a submission.
Yes, my lord.
Okay.
All has got
Then,
holiday. My lord, your lordship is also,
then,
the court is closed.
Mr.
So
Das,
I
let
just
it.
suggest, my lord, one thing can be done, my lord. Only one request, humble request.
No, I am always ready to hear the matter.
That's why I'm saying, if your lordship can take up this matter, keep this matter at 2 o'clock. And if my learned friend is so objecting on my particular state, they are against the state. State has also filed an application on the ground of maintainability. So why not state? My learned friend cannot address, saying that no, my petition should be heard.
So, my lords, my
I
learned
don't
senior
come
will
across.
request the state to
My
take his
lord, why?
place, my lords.
Mr.
State
Nair,
is not making these arguments
please,
today.
Mr. Nair,
They have not made a prayer before my
Mr.
lords.
Nair,
They want to open
but
first.
this is the problem with them, my lord. They will not ask. Whenever we argue something, they will try to say something. My lord, here the state has also filed an application. They have also given reply regarding maintainability. If they are against the state, let state come forward at 2 o'clock tomorrow and argue on the matter of
But
maintainability.
state is not making this prayer. My learned friend is making this prayer, my lords.
State is
My
there, my
learned
lord.
senior friend, my apologies.
State is there. State is representing the state.
My lords,
Mr.
may
Ratan,
kindly have it in the first
advocated
week of July, my lords. We will finish it off in 1 hour, my lords.
He will
Won't
never
take
finish
even
it
1
up,
hour.
my lord. I can write in a piece of paper. They will take another adjournment saying they are busy in some other courts. They have 15 matters. That's the problem.
My lords,
Ms.
be on.
Wang Mao, are you ready
Yes,
to
my
argue
lord.
the matter tomorrow?
Yes, my lord.
Yes.
You are ready?
Yes.
Yes, my lord.
My
So you
apologies.
have filed an application challenging the maintainability of the petition.
Yes,
Yes,
in our
taken.
affidavit, my lord. Yes, my
In
lord, we have
your
taken, my lord.
Yes.
Yes, my lord.
Okay, Mr. Nair, let the government advocate argue the matter tomorrow.
I have the same objection, my lords. With great respect, my lords. I have the same objection, my lord. It is my petition, my lord. It is only on the
Maybe.
suggestion of the third party that the state has
No,
come
not
forward.
third
My lord,
party,
state
not
can
third
never
party.
come forward. It is
Not
not,
third party.
my lord, private party.
No, state will argue the matter tomorrow.
My lords, let it be on any date, my lords, which is prefixed, my lords. My lords, learned ASG has given a date, my lords. It is listed only for the fixing of date, whether it can be preponed or not. My lords, my statement is that it ought
No,
not.
Mr. Nair, you see, on that day when Mr. Raju has mentioned the matter, the other party was not informed.
My lords, we were not even aware that the my lords was sitting, my lords.
Then
So
Is it the
therefore, my lords,
procedure of mentioning the matter?
with great urgency, we could come before my lords through VC, my lords, when we came to know that the list is issued at 10:30, my lords.
Anyway, Mr. Das,
Yes.
let it be on 28th of July as item number 1.
Grateful, my lords. We'll be there, my lords.
At item number 1. Let them,
but,
Mr. Nair, you say, no further chance will be given to you.
Very well, my lords, may record that. I have no difficulty, my lords.
Please, my lord.
A wrong impression has been given, my lords, that normally, my lords,
Should be taken up.
Yes, yes.
my lords, at 2 p.m., my lords.
Pardon?
2 p.m., my
Why
lords.
2 p.m.?
No. As item number 1.
It's a Tuesday,
lord,
my
this is
lords.
not the
It's
way.
a Tuesday. 28th is a Tuesday, my lord. The Honorable Supreme Court would be working, my lord.
Now,
Learned
see, my
might
lord,
be
this is
required.
Monday.
2 o'clock.
Day doesn't
2
work,
o'clock, we will be there, my lord.
No. You manage the matter. Yeah.
That's 2 o'clock, we will be there on 28th.
No.
28th is a Tuesday, my lords.
Sorry.
Put it at 2 o'clock, my lords. We'll finish it by 3 o'clock. Let
Supreme
my senior friend argue after
my
3.
lord.
I have no difficulty.
Supreme Court holiday is going on now, my lord. So
Yes.
all are virtual. So they can also be virtual tomorrow. You are all virtual.
We are not working, sir. We are not working.
So you want that.
We had deferred
You
our
want that,
meeting, as I said earlier, learned ASG is also not working.
No.
These are not done.
It should be fixed at 10:30
Well,
on
have it at
28th
2
of
p.m.,
July.
my lords. There will be a difficulty, my lords, because Supreme Court will commence its functioning, my lords. So therefore, I am saying 2 p.m. we can still manage the board, my lords.
My lord, can I suggest one
We can
thing?
request, we cannot take any matter after lunch, my lords. We can, for an hour, we can argue matter.
On 28th, let us, our petition be started tomorrow itself. Let Mr. Nair note down. What is the difficulty noting down? Government advocate is ready. I am also ready. Let the government start. He will note and your lordship can spill over to 28th. That will become more easier, my lord. You will understand what is about the matter. So let it be at 2. We will note down and let this matter be fixed at 2 o'clock on 28th, my lord. Rejoin the witness. He will give a rejoinder to it.
On 20th. My lords, my learned
No. Mr. Das has been insisting that it should start tomorrow by.
Let's tomorrow. My lords, I don't want to repeat my argument, my lords. I have already made a prayer before my lords. I beseech my lords to.
Okay.
I have put my reasons, my
Mr.
lords.
Das, let it be on 20th at 2 o'clock.
At 10:30.
My lords,
2
20th.
o'clock, they have some difficulties.
He will not argue. I know, my lord.
No, my lords, 20th is still convenient for us.
No, we'll
say
see.
nothing else.
On that day, we'll not grant any adjournment to them.
10:30 will argue on multiplication, my lord. Then we will let him at 2 o'clock. He'll start. Again, he will object. I know. He is always in the habit of objecting, my lord. I don't know why he's
Lords,
objecting.
if there's something legal, I will never object, my lords. If there's something which is not as per the procedure, which is not as per the law, my lords, I'll object, my lords.
Okay.
I'm only before my lords.
Mr. D. Das, learned counsel for the applicant, and also heard Mr. S. B. Razo, learned additional Solicitor General of India, assisted by Mr. Nair, learned counsel for the respondent opposite party, and Ms. Wangmo for the respondent.
Lords, we are for the appellate, my lords. We are for the petitioners.
No. Order is being passed in IA. Please don't disturb at the time of dictation.
My apologies, my lords.
Wangmo. Madam Wangmo, you are in opposite party number?
124, my lord.
124. After hearing learned counsel for both the parties, it is provided that the matter be fixed on 28th of July at 2 p.m. It is being clarified that no further adjournment will be granted to any of the party.
My liberty should be given to argue on the maintainability point. That has to be mentioned. Maintainability point.
This IA not necessary, I think. This IA is for preponing the date only.
I'm sorry.
This IA is only for preponing the date.
No, that's true, my lord. But maintainability point can be also argued, my lord.
Okay, on that day, hearing will be started on the point of maintainability.
Right.
My lords, by the appellant. My lords, may kindly record my statement also then.
Pardon?
That the appellant, the petitioner wants to open the matter, my lords. It is the petitioner's right to open the matter.
Not necessary to mention in the IA.
My lords, if my learned senior's submission is recorded, then my lords may also record my statement, my lords.
Not necessary.
He's
My lords, my lords are not recording my learned senior's statement, my lords.
Pardon?
My lords are not recording my learned
No,
senior.
this IA is listed only for preponing the date.
I'm grateful, my lords. Then no observations are made on Remlio.
But this point of maintainability is there.
My lords, we'll comprehensively.
You have to address it first.
Yes.
This petitioner has to address, no, my lords?
Yes.
Yes, yes, certainly, my lords. On maintainability as well as on merits, we'll address it.
Yes. Yes. Next item.
Yes.
We are grateful, my lords. Extremely grateful, my lords.
Now we will file an application in the meantime for withdrawing this amount in the writ petition also. I'll file an application. Now they will get present. That application we are going to file it, madam.
You were at liberty to file any application.
Yes, yes, we'll file it, madam. Deeply appraised.
Eight, please.
In item 11, I'm saying for legal accommodation for today, madam.
Can we see the last order, my lord?
It's still awaited, madam.
Last order is also simple.
Mr. PN Sharma is not present.
He's there on late, madam. Court of 18. So he requested me to respond an adjournment, madam. Fix it on next week, madam.
Heard Mr. R. Islam, learned counsel for the petitioner. And Mr. Katunier, learned counsel appearing on behalf of Mr. P.N. Sharma, learned counsel for the contender. Mr. Katunier apprised this court that the requisite information as sought for by this court by the order dated 24/4/2026 is not available. And Mr. Sharma is also like in another court. And he requests for listing the matter in the next week, where allowed. SSL list the matter on Friday. Next Friday.
Next Friday.
Coming Friday.
On Monday, madam. Coming Monday.
No, Monday this court will not be sitting.
Then Friday, madam. Obliged.
Obliged.
Let us 4 and 5.
The lordship, the earlier occasion, my learned friend have cited some judgment, my lord. This case. So I have to respond on that, judgment, my lord. Regarding the arbitration clause, my lord.
Yes, you reply it then.
Lord. First, according to their list, my lord, first take up the first case, my lord. It is 2026 INSC 384. Nagreka Income Products versus Cargo Care Logistics, my lord.
Citation?
2026 INSC is number 384.
38.
384.
384. Okay. Yes.
My lord. In this case, first, I rely on the paragraph number 2, my lord. May I read, my lord? The short but significant questions arising in this appeal is when the arbitration clause in the contract uses the word can. Does it necessitate the reference of all dispute to arbitration or is recourse to other dispute resolution mechanism, including that of the civil court, open for the parties, my lord? My lord, in this case, the apex court interpret the word can, which is used in the arbitration clause, my lord. But in our case, the word is may, my lord. So in my humble submission, the facts of
Here you were referring to paragraph number
2.
2. In your case, it is may.
May, my lord. The arbitration clause is this paragraph number 3, later part, my lord.
Okay.
And
So this case is distinguishable from your case.
yes, my lord.
Okay. Next.
Next, my lord, second one is citation is, my lord, 2025.
Yes.
2025 SCC online SC 1471.
Yes.
First, I rely on paragraph number 3, my lord. Under the heading 13, settlement of dispute, my lord. This is the arbitration clause in this case. Para 3. Second paragraph, my lord. 13, settlement of dispute, my lord. It is incumbent upon the contractor to avoid litigation and disputes during the course of execution. However, if such disputes take place between the contractor and the department, effort shall be made further to settle the disputes at the company level. The contractor should make request in writing to the engineer in charge for settlement of such dispute claims within 30 days of arising of the cause of dispute claim, failing which no dispute claims of the contractor shall be entertained by the company. Effort shall be made to resolve the dispute in 2 stages. In first stage, dispute shall be referred to area CGM GM. If differences still persist, the dispute shall be referred to a committee constituted by the owner. The committee shall have one member of the rank of director of the company who shall be the chairman of the company. If differences still persist, the settlement of the dispute shall be resolved in the following manner. In the event of any dispute or difference relating to the interpretation and application of the provisions of commercial contracts between central public sector enterprises, port trust inter se, and also between CPSE and government department / organization, excluding dispute concerning railways, income tax, customs and excise department. Such dispute or difference shall be taken up by either party for resolution through AMRCD as mentioned in DPEOM so and so, my lord. Then, my lord, in case of parties other than government agencies, the redressal of the dispute may be sought through Arbitration and Conciliation Act 1996 as amended by Amendment Act of 2015. So, by this clause, my lord, other than the government agencies, my lord, for the private party, arbitration clause is there, my lord. And then, my lord, paragraph 11. Paragraph 11, my lord.
Yes.
In addition to above, by referring to clause 32 of the instruction to bidders, the learned counsel for the respondent contended that dispute between the parties were to be settled through regular court proceeding and not through arbitration. Clause 32 is extracted below. Clause 32, legal jurisdiction. Matters relating to any dispute or difference arising out of this tender and subsequent contract awarded based on this tender can be subject to the jurisdiction of district court where the subject work is to be executed. So there is another clause, my lord, for settlement of the dispute, my lord. On the basis of these 2 clauses, my lord, para 31, my lord. Para 31, my lord.
Yes.
We do not agree with the aforesaid submission because clause 13 does not bind parties to use arbitration for settlement of the dispute. Use of the words may be sought implied that there is no subsisting agreement between the parties that they or any one of them would have to seek settlement of dispute through arbitration. It is thus an enabling clause whereunder if the parties agree they could resolve their dispute through arbitration. In our view, the phraseology of clause 13 is not indicative of a binding agreement that any of the parties on its own could seek redressal of the intrastate disputes through arbitration. We are therefore of the considered view that the High Court was justified in holding that clause 13 does not constitute an arbitration agreement. Here in this clause, my lord, two aspects are there, my lord. This arbitration clause is enabling, not mandatory. Why, my lord? First, only for the private parties, arbitration clause is there, my lord, not for the government agencies. And second, the jurisdiction of court is there, my lord, for settlement of the dispute. But in our case, these two ingredients are absent, my lord. So facts in this case are totally different from stories. It does an enabling provision in this case, my lord. Next, my lord, number 3, my lord, 2000 volume 4 SCC. Page 272.
Yes.
2000 volume 4 SCC, page 272. Relevant para is para 9. Para 9.
Yes.
Before referring to the said sections, I shall refer to the relevant clauses 4 and 5 in the two agreements dated 15/8/1995. They read as follows. Clause 4. It is hereby agreed that if any dispute arises in connection with this presence, only courts in Bombay would have jurisdiction to try and determine the suit, and the parties here to submit themselves to the exclusive jurisdiction of the courts in Bombay. Clause 5, my lord. It is also agreed by and between the parties that any dispute or differences arising in connection with this presence may be referred to arbitration in pursuance of the Arbitration Act 1940 by each party appointing one arbitrator and the arbitrator so appointed selecting an umpire. The venue of arbitration shall be at Bombay. And here is, my lord, one clause is there for the jurisdiction of the court, my lord. Before, clause number 4, my lord. On this basis, my lord, para 22, my lord.
Para number
22.
22. Yes.
It is contended for the petitioner that the word may in clause 5 has to be construed as shall. According to the petitioner's counsel, that is the true intention of the parties. The question then is as to what is the intention of the parties. The parties, in my view, use the words may, not without reason. If one look at the fact that clause 4 is the jurisdiction of the court, my lord, precedes clause 5, one can see that under clause 4, parties desire that in case of dispute, the civil courts at Bombay are to be approached by way of a suit. Then follows clause 5. With the words, it is also agreed that the dispute may be referred to arbitration, implying that parties need not necessarily go to the civil court by way of suit, but can also go before an arbitrator. Thus, clause 5 is merely an enabling provision as contended by the respondent.
I may also state that in cases where there is a sole arbitration clause couched in the mandatory language, it is not preceded by a clause like clause 4, which discloses a general intention of the parties to go before a civil court by way of a suit, my lord. So in this case, my lord, there is a clause for settlement of dispute before the civil court, my lord. But in our case, my lord, this is absent, my lord. And para 25, my lord. Suffice it to say that the words may be referred using clause 5, read with clause 4. Led me to the conclusion that clause 5 is not a firm or mandatory arbitration clause, and in my view is postulates a fresh agreement between the parties that they will go to arbitration. Point 2 is decided accordingly against the petitioner. Because there is a clause preceding the arbitration clause that the parties may refer their dispute before the civil court at first. So the Honorable Appellate Court rejected their contention that it is an arbitration agreement, which is distinguishable from my case, my lord. My lord. 2025 SCC online, SC 2354. Alchemist. Para P sub clause C, my lord. Pre subclause C, my lord. May I read, my lord? Clause 8.28 of the agreement, which forms the focal point of this list, is reproduced as follows. Para 3 subclause C, my lord. Small c. Para 3.
Yes.
Clause 8.28 of the agreement, which forms the focal points of this list, is reproduced as follows. 8.28 arbitration. The parties shall attempt in good faith to resolve any dispute arising out of or relating to this agreement promptly by negotiation between the executives who have authority to settle the controversy and who are at a higher level of management than the persons with direct responsibility for administration of this agreement. If the matter is not resolved by negotiation pursuant to paragraph above, then the matter will proceed to mediation as set forth below. Any dispute, controversy, or claim arising out of or relating in any way to the agreement / the relationship, including without limitation, any dispute concerning the construction, validity, interpretation, enforceability, or breach of the agreement shall be resolved by arbitration through senior management comprising respective chairmen of the two parties, within bracket arbitrators. Should the dispute not be resolved within 15 days after arbitration, the complaining party shall seek remedies through the courts of law. The demand for arbitration should be made within a reasonable time, maximum 60 days after the dispute or matter in question has arisen, my lord. Next, my lord, paragraph 25. Para 25, my lord. Upon a period clause 8.2, we have the view that there is no indication that the proposed arbitration was supposed to be final and binding. In fact, the penultimate sentence of the clause stipulates that should the dispute not be resolved within 15 days after arbitration, the complaining party shall seek remedies through the courts of law. This suggests an attempt at amicable resolution inter se rather than a definite submission to arbitration, failing which the party has the option to proceed to the court of law. Now, my lord, in this case, the arbitration clause is an enabling provision, my lord, because through arbitration, they are trying to settle the matter amicably, my lord. Not it is binding on the parties, my lord, because in the clause it is says that the should the dispute not be resolved within 15 days after arbitration, the complaining parties shall seek remedies through the courts of law. So it does reflect that this clause is an amicable nature, my lord, not a binding. But in our case, my lord, this clause is binding between the parties, my lord. It is recorded in the clauses, my lord. And secondly, my lord, the appointment of the arbitrators, my lord. Paragraph 26, my lord.
Yes.
Lastly, the individual designated as arbitrators under the clause are the respective chairmen of the parties themselves. Ordinarily, arbitration contemplates reference to third party, a process supported by section 12, read with 7th schedule of the ANC Act. Here, however, the mechanism is akin to an internal settlement process between the chairmen of the two companies. Why this does not ipso facto disqualify the clause from being an arbitration agreement, since it may be waived under the proviso to section 12.5. It remains a significant circumstance in discerning the true intention of the parties. In our case, my lord, adjudicator or the member of the DRC are to be appointed by both the parties. They are neutral person, my lord. But in this case, the chairman of the two companies, they are the arbitrators, my lord. On this ground, my lord, the case has been dismissed, my lord.
Okay.
And my lord, 2007 volume 5. SCC 719. Paragraph 2, my lord. The appellant and the first respondent entered into a partnership as per deed dated 9/1/1964 to carry on the business under the name and style of Empire Art Industries. Clause 16 of the said deed relates to settlement of disputes. The said clause is extracted below. If during the continuance of the partnership or at any time afterwards, any dispute touching the partnership arises between the partners, the same shall be mutually decided by the partners or shall be referred for arbitration if the parties so determine, my lord. In this clause, my lord, shall is used, my lord. Then, my lord, paragraph 9. May I read, my lord, paragraph 9? Para 16 of the partnership deed provides that if there is any dispute touching the partnership arising between the partners, the same shall be mutually decided by the parties or shall be referred to arbitration if the parties so determined. If the clause had merely said that in the event of disputes arising between the parties, they shall be referred to arbitration, it would have been an arbitration agreement. But the use of the word shall be referred for arbitration if the parties so determine completely changes the complexion of the provisions. The expression determine indicates that the parties are required to reach a decision by application of mind. Therefore, when clause 16 uses the words the dispute shall be referred for arbitration, if the parties so determine, it means that it is not an arbitration agreement but a provision which enables arbitration only if the parties mutually decide after due consideration as to whether the dispute should be referred to arbitration or not. In effect, the clause requires the consent of the parties before the dispute can be referred to arbitration. The main attribute of an arbitration agreement, namely consensus and item to refer the dispute to arbitration, is clause 16 relating to settlement of disputes. Therefore, it is not an arbitration agreement as defined under section 7 of the Act. In the absence of an arbitration agreement, the question of exercise power under section 11 of the Act to appoint an arbitrator does not arise. So in this case, my lord, even if the word shall is used, but the appeals court says that the determination and obligation must be present in an arbitration agreement. So, which can reflect that parties are wish to go for arbitration, my lord. But in this case, my lord, the word determine is there. If they determine, then they will go to the arbitration, my lord. So, using the word may or shall is not relevant, my lord. Because here, the word shall is given in this clause, my lord. But there is absence of determination, my lord. But in our case, this is absent, my lord. Because both the parties mutually agree on the terms and conditions of the contract, my lord. Last one, my lord. It is 2012 4 SCC 349. Paragraph 3, my lord. Paragraph 3, my lord. Clauses 15.3 to 15.6 of the contract are relevant and read as under 15.3 jurisdiction of courts. The courts of the place from where the acceptance of tender has been issued shall alone have jurisdiction to decide any dispute arising out of or in respect of contract. Then 15.4, in case of any dispute or difference whatsoever arising between the parties out of the relating to the construction, interpretation, application, meaning, scope, operation, or effect of this contract, or the validity or breach thereof, Concor and the supplier shall make very effort to resolve amicably by direct informal negotiation any disagreement or dispute arising between them under or in connection with the contract. Then 15.5. If after 30 days from the commencement of such informal negotiation, Concor and the supplier have been unable to resolve amicably the contract dispute, either party may require that the dispute be referred for resolution by arbitration in accordance with the rules of arbitration of the Standing Committee on Public Enterprises of India from the conciliation and arbitration, and award made in pursuance thereof shall be binding on the parties, my lord. This is the arbitration clause. First clause is regarding the jurisdiction of the court to take up the differences between the parties. Then paragraph 7, my lord. Paragraph 7, my lord. From careful scrutiny of clauses 15.3 to 15.6 of the agreement between the parties, it would seem that the expression may has been used only in clauses 15.5. In clauses 15.3 relating to jurisdiction of the courts, the expression used is shall, which indicates mandatory nature of the term agreed between the parties with respect to territorial jurisdiction of the court. Similarly, in clause 15.4, dealing with negotiation, the expression uses is shall, clearly implying that it would be mandatory for the parties to make efforts to resolve their dispute by way of negotiation. On the other hand, Though clause 15.5 gives an option to one of the parties to seek reference of the dispute to arbitration as per the rules of Standing Committee on Public Enterprises, it does not mandate a compulsory arbitration for adjudication of such dispute. In case arbitration is sought by one party to the dispute, the other parties had an option whether to agree for resolution by arbitration or not, and the party seeking arbitration could not compel the other party to go through the process of arbitration. Normally, the arbitration clause stipulates that the dispute between the parties shall be referred to arbitration, and the expression may is not used in such clauses. Now, this is important, my lord. Though it can hardly be disputed that mere use of the expression may would not be determinative in every case. And in a given case, the terms and conditions and the conduct of the parties may lead to an inference that despite using the expression may, the parties had in fact agreed for a compulsory arbitration to resolve their dispute, my lord. So here in this case, my lord, the word may is used. But the honorable court says that determination and the obligation of the parties has to be read from the terms of the contract, my lord. Then, my lord, paragraph 8, my lord. Paragraph 8. A perusal of clause 15.3 would show that the parties agreed that the course of the place from where the acceptance of tender is issued alone shall have the jurisdiction to decide any dispute arising out of or in respect of the contract. This clause clearly contemplates action of dispute by civil court, though only by the court at the place where the acceptance of the tender is issued, that is New Delhi, my lord. So in these cases, my lord, there always exists a clause, my lord, regarding settlement of dispute through the civil court, my lord. But in our case, all those ingredients are absent, my lord. So in my humble submission, my lord, the facts of this citation are not applicable in our case, my lord.
Okay. So your part is completed.
May I just give a short reply?
No,
May I
no.
just
He
on
has
this-
only referred the cases
Yes,
which
no, I
you have
just point out one
relied
more
upon.
thing. Perhaps my learned friend is trying to portray before your lordship.
No, he want to distinguish the
Yes, he has
cases
distinguished-
referred by you
Yes.
from
Now-
the present case.
Present case. Now, otherwise also, my lord, as my learned friend has tried to portray what I could understand, that yes, if there is a clause which says that you can go to the court, and if there is a clause which says arbitration, then, my lord, this clause will be applicable. The judgments on which I have relied, my lord, your lordship will see that, suppose, my lord, this page 11 for judgment, my lord, that page 11 of the judgment. 25 SCC online 1471. Now, my learned friend has tried to say that as there were this clause 13, page 11, lordship, that a bunch of judgments, my lord, page 11. Yes. Now, my learned friend has referred to this clause 13, settlement of disputes. Then, Lord, my learned friend has taken your lordships to paragraph 31 at page 23. Now, at page para 30 also, my lord, we should read, my lord, because the at page 23 para 30, because these 30 and 31, the findings of the Honorable Apex Court is not considering that there are
No,
other.
you have on the other day you have referred to paragraph number 30 also.
Yes, that is why, my lord.
Yeah.
So I have underlined also. So, my lord, the proposition of law, now these are the judgments delivered by the Honorable Apex Court. Now, what is, my lord, the effect of this? But law declared under 141 of the Constitution of India, my lord, the law declared by the Supreme Court is the law of the land. So the law point, my lord, can be taken at any point of time. That apart also, my lord, I'll just take your lordship, if your lordship will kindly, these on the face of it, my lord, this agreement does not constitute an arbitration agreement, because for a moment at 10 of the petition, my lord, at 110, my lord, Lordship will kindly, Lordship is taking up that FAO, my lord.
Mm.
Page 110. Hardly 5 minutes. I'll just point out these things. Yes. Page 110. Lordship got it, my lord? On the left hand bottom, dispute resolution 23.2. Now 23.1 says that amicable settlement. Now 23.2, any dispute between the parties as to matters arising pursuant to this contract which cannot be settled amicably within 30 days after received by one party of the party's request for such amicable settlement may be referred to adjudicator or dispute resolution committees. That means if no amicable settlement, it will go to DRC. Then your lordship will for a moment come to next page, my lord, page 111, clause 25.2.
Oh, you are repeating the same.
No, but
thing.
I'm just pointing out that even assuming may, shall, apart from these, on the face of it, my lord, it does not constitute an arbitration agreement because this is not in conformity with section 7 of the Arbitration Act. Only 25.2, my lord. Lordship got it? Next page. Either party may refer a decision of the adjudicator or the DRC to an arbitrator. Now, previously it says that amicable settlement, no amicable settlement, then you will go to adjudicator. Then what will be referred to, my lord, arbitration? The finding of the adjudicator will be referred to arbitration. Now, what does section 7 of the arbitration clause says, my lord? What you will kindly arbitration act. Clause, my lord, section 7 of the Arbitration Act. Section 7, Lordship got it? In this part, arbitration agreement means an agreement by the parties to submit to arbitration all or certain disputes which have arisen. So, before an arbitrator, my lord, as per section 7, all the disputes has to be submitted. Now, what does this clause say? That the findings of the adjudicator will be submitted before the arbitrator. Am I clear, my lord? Because this 2 clause says that first of all you try amicable settlement, no amicable settlement, go to adjudicator, and then the finding of the adjudicator will be referred to arbitration. But the Arbitration Act says that it is only the disputes between the parties will be referred to arbitration. So therefore, on the plain reading of these section 23 and 24, my lord, no arbitration clause has been made out. Because in 23, lordship has seen that any disputes will be referred to adjudicator, and not that the finding of the adjudicator will be referred to. And otherwise also, my lord, the plaint could not have been returned. The order that the return of plaint, that is also, my lord, perverse, because if section 8 application code says that there is a clause of arbitration, the parties may be directed to go to arbitration. When there is no question of some returning of the plaint.
Okay.
And as per that, my lord, just section 8 also, my lord, there is no finding in the, my lord, impugned judgment. There is no finding in the impugned judgment that, my lord, prima facie no valid arbitration exists, my lord. Section 8 also, my lord. Power to parties to refer to arbitration where there is an arbitration agreement. So 7,
Because, my lord. Section 8.
Section 8. Last part. And power to refer parties to arbitration where there is an arbitration agreement. A judicial authority before which an action is brought is in a matter which is the subject of an arbitration agreement shall, if a party to the arbitration agreement or any other claiming through or under him so applies not later than the date of submitting his first statement on the substance of dispute, then notwithstanding any judgment, decree or order of the Supreme Court or any court, refer the parties to arbitration unless it finds prima facie no valid aggravation. So that is regarding return of plaint, it cannot be return of plaint. It should be that the matter should be referred to arbitration.
Okay. We'll list the matter on Friday. On that day, if any clarification is necessary, then I will ask you. Otherwise, on that day, we'll pass the order.
I am of the view. Because this apex court's judgment, my lord, it clearly says that what is an arbitration agreement, in what circumstances it may be constituted.
Heard Mr. Edas, learned counsel for the appellant, Mr. Borua for the respondent. Argument concluded, list the matter on Friday, 12th of June.
I am obliged.
Obliged.
Number 6.
But through this application, we have prayed for removal of the executor of a will under section 301 of the Succession Act.
Section
301 of the Succession Act.
301.
Yes.
What the 301 states?
301 says, so long the executor is performing as per the direction or objective of the will, or as per the directions of the deceased testator, he may continue with the office. But the moment he deviates from the objective of the will, he needs to be removed. And that power, only the High Court has the power. 301. It says, may I read,
Now the executor has been performing against the
against
terms and
the
condition of the
yes, objective of the will.
will.
So what happens, the Sambhunath Ghosh, he died. The father, the testator, he died on 17/9/2021, and he left behind a will, The will is at page 21. So, my lord may come to page 22, just for a quick look of the what is the provisions of the will, May I read,
What are the provisions?
Yes, I'm reading, page 21, from the third line, my married daughters are choosing of take part in this bequeathed property. I, in consideration of my 4 sons, do hereby give and bequeath my immovable properties mentioned in schedule below. I leave and bequeath all the cash, securities, shares, debts, and monies, whether at the bank or else, whole to my son, namely Sri Gautam Ghosh. Gautam Ghosh is the executor. I do hereby declare appoint my elder son Sri Gautam Ghosh as executrix to my will, and he will take probate of the will, and I do hereby appoint him executor for this purpose out of 4 sons. Now, next paragraph, be it mentioned that the executrix of the executor, as the case may be, will pay off the cost of probate proceeding, that my funeral expenses and Shraddha ceremony out of the cash amount deposited with my banks. Now, my lord, there are schedules here in this will, wherein the properties were being distributed amongst the 4 sons. And the petitioner, along with his 2 sons, they got properties schedule A, B, C, and D. Now, my lord, he has a landed property, is a valuable property in Maligaon, Gauhati, Maligaon, my lord. So, out of that land and building, my lord, the petitioner and his sons got a schedule A, B, C, and D. Now, what happens, my lord? Schedule B and C properties, they are given rent by the executor. So he has executed all tenancy deeds and all, my lord. he is collecting the rents at the cost of my knowledge, my lord, and he doesn't divulge any information regarding that, my lord. So, my lord, schedule B and C is I'm not enjoying at all. Now he says that that he have been giving us share of the rental amount and all. But whenever we approach him that what is the rental amount, what we get, he doesn't disclose anything, my lord. Now, my lord, kindly see this as per 213 of the Succession Act, without probate, my lord, there is no effect. There is no effect regarding so far as the properties are concerned, my lord.
So
my lord,
probate was granted.
No. Probate is still to be granted. He has not filed yet, my lord. He is yet to file the probate. That is why, my lord, before end of the limitation period, we send a notice to him. Kindly see our notice, my lord, at page.
No. If the probate was not granted, how can he deal with the properties mentioned there?
No, that is why being the executor, my lord, he can manage the properties. The properties can be managed by the executor till the time it gets probated.
Okay.
So that is there. As per 213, only after getting the probate, the beneficiaries obtain the title of the properties, my lord. Now, my lord, before the probate is done, my lord, the executor will manage everything and he will file a probate during the limitation period. So, my lord, what we did, my lord, because of his negligent attitude, my lord, we send him a notice. Kindly see the notice, my lord, at page 33. 33 is the notice wherein we have clearly stated, may I read, my lord, that you had revealed to my client that you have been possessed with the original will dated so-and-so, left behind by the deceased father of my client, namely Shambhunath Ghosh, so-and-so. That the deceased father of my aforesaid client died on 17 September 21, and he had bequeathed the property situated at Gulapi Bhavan, Maligaon, Gauhati through will dated 15/10/19 among the four sons, namely Gautam Ghosh, Vikas Ghosh, Shankar Ghosh, and Mithun Ghosh. That after the death of the father of my client, it is been extremely important to file the probate case by you as the executor of the will dated so-and-so for mutual convenience and exclusive title of the legatees. That despite repeated requests from my client for execution of the will dated so-and-so, you have been negligent and you have been delaying the same with excuses for reasons best known to you. Your negligence had resulted in great inconvenience as you have been deducting lump sum amount from the individual rent receivable by my client through the bequeathed properties without rendition of account. That the aforesaid incident being one of many incidents which are creating much inconvenience to my client, and being petty businessman, he is having great difficulty in maintaining his life with peace. That you have been acting as the administrator without there being any probate of the will, as you are managing all the rental properties without consent from the residual legatees, for which the objective of the will is getting frustrated since the death of Shambhunath Ghosh on 17/9/21. You are therefore asked to take all such lawful steps within 30 days from the date of receipt of this notice to execute the will dated so-and-so, left behind by the deceased father of my client, thereby filing the probate case before the competent court of law with jurisdiction, failing which, please take notice that I have specific instruction of my client to do all such legal steps towards execution of the will dated so-and-so and other allied lawful steps in facts and circumstances of the case. Now, my lord, against this reply, my lord, he sent me a notice. Kindly see notice, my lord. His reply, page 36. Relevant 37, my lord. I will just straightway take your lordship to the relevant portion. Page 37. Now, when I asked him to file the probate, since the testator has already mentioned in the will that out of the cash amount deposited in the bank, he will have to file the probate case. That is exclusive from the will, reading of the will. Now he says, my lord, page 37, kindly see, it is pertinent to mention that the mother late so-and-so, wife of late Shambhunath Ghosh, predeceased of her husband, but her death certificate has not been obtained till serve of your advocate notice dated 17/9/24. I do hereby requesting you on behalf of my client that you will obtain the death certificate of deceased Kamala Rani Ghosh expeditiously and join hand with me, with my client to file the probate case. And I do hereby inform you on behalf of my client that you should be arrange the expenditure regarding filing of the probate case and stamp duty as your part. Now he directly refuses, my lord. He has gone against the will of the testator, my lord. Now, my lord, again, page 38, my lord. Kindly come, my lord, page 38. And you have tried to make dissent and confuse to conclude. I am not understanding what is this word, my lord. Conglutinate each other, and my client requesting you to obtain the death certificate of deceased Kamalani Ghosh explicitly, and you should be arranged the expenditure regarding so and so, so and so. That in reply to para 7, you have asked to take lawful activities of filing the probate case before the appropriate forum within 13 days. It is fair decision made by you, though the pleader notice dated so and so, but for filing the probate case should be required the death certificate of deceased Kamalani Ghosh, and also require the expenditure regarding filing the probate case and stamp duty as per the court prescribed direction in this regard. And so his demand is, my lord, I have to join hand with him and support with the monetary aspect and all. So this was his reply. Now, my lord, kindly see page 28, my lord. Page 28. This is a tenancy agreement. This tenancy agreement, my lord, see Gautam Ghosh with some Pranav Kumar Datta. And this property, my lord, that this property, my lord, and whereas the aforesaid second party at page 29, my lord, I'm reading, has approached the first party to lay out portion of measuring so and so feet breadth of the said RCC building on monthly rent business purpose go down, and the first party owner is also desirous and willing to lay out the same. And clause 2, my lord, that the monthly rent of the aforesaid premises has been fixed at rupees 3,500. And this property, my lord, premises is, my lord, Schedule B and Schedule B property, my lord. Schedule B in my petition, my lord. Schedule B, my lord. 6.5, page 17, my lord, of the petition. .5 feet by 26 feet, located at front side of the extreme right corner of the first floor, Gulapi Bhavan. Now, my lord, if you see the will, my lord will find that premises being allotted to my son at page 23, my lord. I'm sorry, 24, my lord. Oh, I'm sorry, 23, my lord. Point A, my lord. Page number 23, point A. That one room area measuring 20 by 5, 100 square feet in the front part of the right corner side of the corridor of the Gulapi Bhavan will go to my youngest son, Mithun Ghosh, and the two shop rooms, first floor of front side, right corner of the Gulapi Bhavan area, measuring 6.5 into 26 feet each, total 676 square feet will go to the share of Ankush Ghosh and Priyankush Ghosh. Both are sons of Shankar Ghosh and my grandsons. They are also petitioners in this petition, my lord. Ankush and Priyankush. So, my lord, now, my lord, against this petition, my lord, respondent 1 had filed an affidavit in opposition. Kindly see, my lord, their affidavit in opposition. They have, my lord, annexed the bank statement. Again, they have also repeated, my lord, that the cost of the probate has to be borne by me, my lord. So, that is all right. I can still bond the cost. That is all right. But he has failed to file the probate case during limitation, my lord. So, my lord, he has again annexed one statement of the bank. Kindly see, my lord, page 45. This is the account, my lord, left behind by the deceased. That is Punjab National Bank, my lord. Now, he has annex the statements from 11-10-2015 to 14-12-2020. Page 46, my lord. Now, what is the point, my lord? The deceased, he left behind on 17-9-2021. Now, this statement, my lord, this is utter disregard to this honorable court, my lord. He has annexed the statement up to 2020 only, 14-12-2020, before the date of the testator, my lord. So what does he want to portray before this honorable court, my lord? He is hiding what is being left behind by the testator, because post 17-9-2021, what he has done with the cash amounts deposited. So he has given a partial picture of the account, my lord. So he needs to file the accurate statement, my lord, as on date, after the date of the testator. But he has not done that till date. So I have also filed my reply against their affidavit in opposition. So, my lord, apparently from the facts and circumstances of the case, the respondent number 1 has been doing against the will of the testator, my lord. And when he does so, my lord, there is no other, my lord, alternative but to remove the executor from the remove him as an executor of the will. Now, my lord, I have filed this petition, my lord, just because the limitation period got exhausted, my lord. Taking into account the COVID period limitations, my lord, we have filed it on in the month of February 25, my lord. And the limitation, my lord, would get exhausted, my lord, within March 2025.
You not file this application within the limitation period?
Within the limitation, my lord.
Okay.
So my prayer is that, my lord, he may be removed from the executorship, my lord, and my lord will grant us, my lord, time, giving limitation, extension of the limitation, my lord, so by constituting anyone, my lord. One honor learned register of this honorable court can be also the, my lord, executor of the estate, my lord. So that is there, my lord. May I rely on one judgment, my lord, regarding this? This of Madhya Pradesh High Court, my lord, just for your lordship, my lord. In this case, my lord, page 416, my lord.
Yes.
Yes, may I read, my lord, from the bottom portion, my lord. If my lord has got it by force of section 211 of the Act, if my lord has got it, my lord. The executor of the deceased person in his legal representative for all purposes and all the property of the deceased person based in him. As such, he derives title under the will and immediately upon the testator's death, testator's property based in him. There being no interval between the testator's death and the vesting of the property. His personality vis-a-vis the property of the testator is distinct from that of a trustee. For the executor has a general power to receive and pay what is due from due to and from the executor estate, while trustee has power to pay what is vested in him as trustee to the persons for whose use he holds that property. The property does vest in the executor for purpose of administration and in the legatee for enjoyment. All that executor has to do is to accept the office as executor, and the property does vest in him. He therefore can do all that the deceased could have done in respect of the estate. Such vesting, however, is not of the is not of the beneficial interest in the property, which interest vests in the legatee only, but the vesting is for purpose of representation only. Section 213 of the Indian Succession Act 1925 provides that no right as executor can be established in any court of justice unless a court of competent jurisdiction in India has granted probate of all the will under which the right is claimed. The provision is made applicable to certain classes of cases as enumerated in subsection 2 of section 213 of the Act. The analysis of the aforesaid provisions would indicate that because of such interests created in the executor in respect of the property of the deceased representing the legatee, he can manage the entire estate as the deceased himself would have done. He is responsible for the execution of the last will of the deceased. By naming a person as executor in the will, the testator expresses his utmost confidence and also, this is important, my lord, also feels confident that his last wishes shall be carried out in the manner indicated. It is important, my lord. It is therefore clear that a person who is named as the executor in the will of the deceased may be allowed to continue to act as the executor and represent the estate of the deceased and continue to manage it so long as he maintains the confidence reposed in him by the deceased and commits no breach of that confidence. The moment he does so, he ceases to be the person competent to continue to hold that office. Such person in the event has to be removed and some other person has to be appointed succeeding him. Such a power has been given to the High Court only under section 301 of the Succession Act, my lord. And my lord, also, my lord, one observation at page 418, my lord. Withering away the property to the detriment of the interest of the legatee, it shall be justified in exercising his jurisdiction under this provision in removing the executor and succeeding him by another. In such cases, main guide must be the welfare of the beneficiary. Want of honesty or want of proper capacity to exercise duties or want of reasonable fidelity may well justify an order under this section directing removal of the executor.
Okay, okay.
And one more decision of the Honorable Supreme Court also, my lord, regarding the effect of will, my lord, without the probate, my lord, no one can have the enjoyment, my lord. It's just being established, is observed in this judgment, my lord. Page para 7, my lord. So my humble case is, my lord, he has already, my lord, he has admitted that because of the, well, he wants me to join hands, my lord. That is absolutely okay, my lord. But from the will itself, my lord, the statement of the affidavit, my lord, goes to show that he is acting against the objective of the will, my lord.
Okay. Yes.
Make with it, madam. My lord, this is a very unfortunate case, madam. Before I say anything, madam, may I take my lord to the will, my lord? Late Sambhunath Ghosh was a very wise man, my lord. He knew that my lord, his sons will be fighting amongst themselves. Which they used to do before his death also and after his death also, my lord, we are still fighting. My lord, that is also reflected in the will. If my lord comes to the first page of the will, my lord, I'm reading from the last 5 lines. Shankar Ghosh, aged about 46 years youngest, fourth son of Mithun Ghosh, aged about 36. My sons has become most ungrateful to each other and not to make well relationship between themselves, for which I may not expect any point of love and sympathy, has prompted me to execute this my will and testament. The irrelevant relationship and unfitful behavior amongst themselves and to me have also inspired me to make a will to maintain peace during the later part of my life. I give my immovable properties mentioned scheduled below. So, my lord, there was fight going on between the brothers. Still, it is going on, my lord. And the main purpose of the will was, my lord, that the brothers will enjoy the property amongst themselves. Now, my lord, why I say these things? Because, my lord, if a will has to be probated, then naturally, my lord, court fee has to be paid. And this is a plot of land measuring about 1 kotha 6 lesas. Over that, G+4 building is there. So the property value will be around more than 1 crore, my lord. If I file a probate case, that would ipso facto not give me the entitlement to do, my probate will be granted. Once probate is granted, my lord, before probate is granted, valuation part is there. And if the property is valued more than 1 crore, my lord, at least I have to pay around 7-8 lakhs of rupees as a court fee. Minimum, I'm saying, my lord. So that is why I'm asking them if you want me to pay, because the property that was laid by that Sambuna goes through the bank accounts. If my lord has seen the bank account, my lord, there is only 1,500 rupees pending. So how can I pay, my lord, from those accounts? I have to invest from my own money, my lord. That's why I'm saying that my brothers, please come join hand with me. I will file the probate case. There's no harm in filing the probate case, my lord, provided we all share the expenses. Today also I'm ready and willing to file the probate case, my lord, but they are not coming ahead to file the probate case. If they want to join, my lord, if they want to share the property, my lord, they have to come, they have,
No.
my lord.
The burden to file a probate case is lies upon you.
Lies upon me. Lies upon me, my lord, thereafter, my lord, then, my lord.
And nowhere in the will it is provided that the other brothers will also have to
Absolutely
share.
correct, absolutely correct, madam. But madam, just the next two lines, be it mentioned that the executrix or the executor, as the case may be, will pay off the cost of the probate proceeding, that of my funeral expenses and Shraddha ceremony out of the cash amount deposited with the banks. So if in the bank account, madam, there is no money, what am I supposed to do, madam? Because it doesn't say that I have to pay from my own pocket also. And it is not at all, my lord, believable, or my lord, it cannot be expected of me that I'll pay around 7-8 lakhs, madam. So that's why, my lord, they have sent me a notice. In fact, I have sat with them also before filing the probate case also, my lord. That please come and join hands with me. We'll file it together. I'm the executor, I'll file it. But please bear the expenses with me. That is my simple and respectful submission, my lord.
No, that's all right. But if it is not provided in the will, why they will pay?
If they don't pay, my lord, who is going to pay? Because, my lord, in the will it is said that my cash amount deposited with the banks, but that is not been taken care of because with the banks only 1,500, 2,000 rupees is there.
No, that is prior to the date of the this testator.
My lord.
Where is the recent account?
Recent account, my lord, at that time I was not there, then I'll try to get the base copy, my lord, of the 2009, 2021 it expired. I'll try to get the copy, my lord. And I'll file it, my lord. If only because of that reason, my lord, but my lord, that will delay the matter. What I'm suggesting, my lord, let us, I'll file the probate case, my lord. Let them also say that, my lord, we'll also share the expenses, my lord. Because
No, that my lord will decide. But that thing is that beyond the will, my lord, he cannot go. What is being provided in the will. So, my lord, so far as this bank account is concerned, he has admitted he has not given the accurate accounts, my lord. And now, my lord, kindly see this
December it was given, my lord.
Sambhunath Ghosh has been a terror, my lord. He last time in April, my lord, he hit me. There was a big fight, my lord. He suddenly, unprovokedly, my lord, he hit me, my lord. I got bleeded, my lord. I went to hospital. I went to police station. FIR was filed. Then it was compromised. That's a different issue, my lord. He is a terror, my lord. He doesn't, my lord, listen to anyone. He doesn't listen to anyone, my lord. And that is why we have been requesting him for the last so many years, my lord. Kindly file the probate. Kindly file the probate. All that he does, my lord, he doesn't listen to me anything, my lord. That is why I was compelled to send a notice, my lord. Otherwise, my lord, why should I have filed this petition before the honorable court?
Anyway, are you ready to make payment of some of the amount?
Filing,
Well, let them file the up-to-date statement as an additional affidavit first, my lord. Then I will take my instruction also, my lord.
Okay. Heard Mr. Chakraborty, learned counsel for the appellant, Mr. Iqbal for the respondent. Heard in part, list the matter. When?
After vacation.
After vacation. Okay. Okay.
The date may be fixed.
As ordered. And in the meantime, Mr. Iqbal, learned counsel for the respondent, shall produce up to that bank statement of the bank account number.
By way of an
Account number, my lord.
Punjab National Bank.
Account number.
My lord, it find it page number 45, my lord.
45.
Of the affidavit operation.
Account number 4589. Page 40.
4589 001 001 0000 0151.
Yes.
By way of an affidavit. And further, Mr. Iqbal submits that if probate case is filed, then the respondent herein has to pay court fee amounting which may goes up to rupees 8 lakhs.
Which may go up to 8 lakhs, my lord.
Up to 8 lakhs.
Depending
And,
upon the value of the property.
depending upon the value of the property, and the respondent herein has no such amount in the no such credit in the said bank account, and as such, if the applicant herein one applicant or appellant is one or
No, we're three applicants.
if the appellants herein are ready to share some of the portion of the aforesaid amount, then he will file then he is ready to file the probate case. In that view of the matter, it is provided that Mr. Chakraborty, learned counsel for the appellant, shall obtain instruction as to whether the appellants herein are also ready to share some of the portion of the aforesaid amount of court fee to be paid.
Well, may I submit one thing? Well, there's a division bench judgment, perhaps, my lord, I have to check out, my lord. Saying that, my lord, in probate proceeding, my lord, this court fee, my lord, will be maximum ad valorem court fee, my lord, that is applicable. There's a judgment of Assam Tribune, my lord, private limited, and all, my lord. Perhaps it's there, my lord. So my learned friend, what he has submitted, that it could probably go to 8 lakhs and rupees. I think that is not the case. That may not be the case, my lord.
Okay, all right. You obtain
Yes,
instruction
yes.
on NASDAQ, or you
Yes.
produce the decision.
All right.
Oh. Okay, none appears for the appellant on call. Is the matter after a week. It will decision be about the